Madam Chairman, you are live.
Wonderful, thank you. Well, good afternoon. This is the Senate Judiciary Committee on this Wednesday, February 24th. It is great to have everyone joining us today, my second day of legislative meetings, in anticipation of next week us being live and going 100% here. So we'll start this meeting. We're going to have 4 bills for us in front of us. Senate File 49, deferral of criminal sentence amendments. Senate File 6, public works contracting requirements amendments. Senate File 87, voyeurism amendments, and Senate File 90, hemp prohibitions and requirements. And that's if time allows. I do anticipate we should be able to get through all 4 bills. We have a 4-hour time slot, but it is a hard stop at that 4-hour mark. But if we aren't unable to get to any of the bills today or Senate File 90, I want the public to know we'll hear it next week when we're back at the Capitol and going live. So not to worry if we're unable to get to any of these bills today. A message also to the public for any other bills that have been assigned to Judiciary Committee but haven't been scheduled yet. All of those bills will be scheduled. We have plenty of time. They'll be heard in the March session. So watch the calendar accordingly for when those bills may be scheduled. With that, Danielle, if you could start with roll call.
Madam Chairman, we actually have Judy Eatman, the secretary for the meeting today, and so she'll be taking the roll for you.
Wonderful. Welcome, Ms. Eatman. Great to see you. We understand there's technical, so I think committee, as you heard, and members of the public, we're going to do this hybrid this session. So we'll be live at the Capitol and some remote, which will be, I think, allow for greater public participation. But as a result of this being the first go round, there's going to be some technical challenges. But we're used to that at this point, having been pretty technical all for 2020. So not to worry.
Madam Chairman, I would be happy to take the roll if there are technical difficulties.
Sure. Ms. Eatman, are you available to do roll call? Looks like maybe she can't hear me, or you're working on it. Give me a thumbs up if you're working on it. All right. Well, I can keep talking. Yeah, so this week is kind of a test session where I was asked to go to the Capitol to chair the meeting maybe from there, but I declined, knowing that at this point in time, if I'm going to be on Zoom and have a Zoom meeting, it's much easier to do it where I'm already set up and my technology is working. So this was part of the reason, but I think the travel committee, where Senator Koss testified yesterday, Chairman Ellis did appear from the Capitol. That seemed to work out okay. I was not that ambitious. Well, it looks like they're on the phone, but they'll get it managed. We'll introduce Ms. Eatman here when she's able to get her sound working. But with that, Danielle, maybe you want to get us going with a roll call?
Yes, Madam Chairman, I'll do that now. Senator Cooper?
Here.
Senator French?
Here.
Senator Kolb?
Here.
Senator Cost?
Here.
Chairman Nethercott?
Here.
You have a quorum.
Well, wonderful. We'll go ahead and get started with that first bill, Senate File 49, deferral of criminal sentence amendments. And I do believe we should have the good Senator Case available in the waiting room. And Danielle, will you be helping with that?
Yes, Madam Chairman, I just admitted him and he should be coming up here in just a second.
Wonderful.
Hello, Madam Chairman.
Hello, good Senator Case. Ms. Creech, if you could let in Mr. Peterson as well, I think he'll be testifying with Senator Case. So for the ease of transition and having people available for public testimony, we'll get him in the wings and bring him into the waiting room as well, or into the meeting. Senator Case, welcome. I understand you want to do a deferral of criminal sentence amendments. If you could walk us through your bill, that would be most helpful.
Yes, Madam Chairwoman, I brought you this bill. I hope you'll look favorably on it. Before I begin, I just want to say hi to Judiciary because this was my very first committee in the legislature over on the other side of the Capitol. And I spent some time there and with some people that became very great friends. And I thought it was a fabulous committee and worked so hard. What a great committee. A lot of respect for Judiciary.
You thought it was the #1 committee. Isn't that so, Senator Case?
It was #1 over there. It still is. I've been working my way up since then. I dropped all the way down. I was 10 for a while, and I did work up to like a 9, and I think I'm at a 3 now, Madam Chairwoman. I'll never make it as far as 1.
We'll bring you back. We'll bring you back.
All right.
Whenever you're ready.
Well, thank you very much. It's a simple bill. It's a policy question of the legislature, and it regards the deferral of sentence, what we call a 301 proceeding. And it's called 301 because the statute numbers, it's in 713-301. Article 3 is probation and suspension of sentence. The philosophy behind this, Madam Chairwoman, and I'm sure I know you know, is that you kind of give people a chance. And if they conform with a significant period of supervision, their conviction is never entered into the court. And in essence, they get a free one. As it now stands, the terms of it are that the state or the prosecution has to agree to this arrangement. That seems a little one-sided to me, and especially with the adversarial nature of the justice system and how things happen. My bill removes the requirement for the state to agree to the 301, but of course maintains that it's the court's jurisdiction. That's it in a nutshell. I come about it mainly to the influence of Mr. Peterson, who's now joined us. He was formerly a resident of Lander, and we missed him very much. And I've been involved in following his career as an attorney and frequently as a public defender. And that is the genesis of the bill, and I yield my time to him. I'd be happy to answer any questions, though.
Thank you, Senator Case. Any questions for the good senator? All right, wonderful. We'll stand by, Senator Case. I think we do have a lot of public testimony on this, which will help us make that policy decision, but we'll give you an opportunity to come back around and round it out after we hear from all of them. So stand by. Mr. Peterson, welcome to the committee. I understand you're a University of Wyoming College of Law graduate, and that therefore means you're a brilliant lawyer. So welcome to the #1 committee, Judiciary, and good to see you. If you could introduce yourself despite my introduction, that would be most helpful, and we look forward to hearing your comments.
Good to see you as well, Madam Chairwoman, and other senators of the Senate Judiciary Committee. It's my pleasure and honor to be testifying in front of you all today. And I want to thank Senator Cale Case for being willing to sponsor this bill. And not only this bill, but Senator Case and I have worked on a previous bill that was similar in a way. That we were able to successfully push through a couple of years ago. And I think it's been going really well. And so we have a history of working together. And I want to thank him for always being an open ear for criminal justice reform. I think it's something that he has made a priority in his time in the Senate. And we've kind of got it where, you know, if I'm just out in the field and I'm just running into sort of a brick wall over and over again, he's a person that I can call and say, hey, I've got an idea for a bill, and what do you think? And he's been great and receptive and very helpful. And I look forward to continuing to work with him and all the Judiciary Committee members. I am a graduate of the University of Wyoming Law School, along with yourself, Chairwoman Nethercott. And I have been a Wyoming lawyer for 12 years now. I clerked for the Honorable Norman Young in the 9th Judicial District in Lander for 2 years. I learned a great amount from him. I went into private practice in Fremont County. I was a public defender for about 7 years, and I'm currently in private practice with Fleener Peterson, and our main office is in Laramie, and we mostly do criminal defense work. I'm also an adjunct professor at the University of Wyoming, where I teach 2 courses. And that's been a great honor as well. I'm sure that the committee is familiar to a large extent with 7-13-301. In the criminal justice world, we just call it a 301 many times, but it's really more properly referred to as a deferred prosecution, and even perhaps more properly referred to as a first offender treatment. And really the way it works is if you've never been convicted of a felony or some other disqualifying crimes, and you are not currently charged with a violent crime, then you are eligible for a deferred prosecution under 7-13-301. And the way that it works now, as Senator Case pointed out, and just so the committee knows, I believe Diane Lozano is in the waiting rooms and is going to testify about the impacts this has on her agency, the Public Defender's Office, and some others that I've wrangled in here today. But the way it works right now is that prosecutors basically have a veto power. And I don't know that anybody foresaw that when we started with 7-13-301. It's kind of unique in the law. There is a deferral, a similar deferred prosecution procedure under the Controlled Substances Act, 35-7-1037, that does not require the prosecutor's consent and does not give the state a veto power. And that works just fine, and it works great. And So with for example, for the 1037 under the drug statutes, controlled substances, if you have a possession of a controlled substance charge, the prosecutor can disagree and argue against a deferred prosecution under 1037, and the defense counsel can argue for it. And ultimately, that decision is up to the judge. And sometimes the court goes along with the state, and sometimes the court goes along with the defendant. But at least in those circumstances, we get to ask for one. We get to argue for one. With the 301, which applies to all crimes other than violent crimes, if the prosecutor says no, we don't even get to ask the judge for one. And I can tell the committee that in my experience working with Judge Young, and also just in my 12 years as a lawyer, there are many times when the court would love to give someone a 301, particularly a young person that has no criminal history and does not want to saddle that person with a felony conviction for the rest of their lives, that they know will affect them for job applications, federal grants and programs, housing, bank loans, all kinds of things, for what is essentially a blip on the radar and a out of character act. But the judge can't do it if the prosecutor says no, and the judge can't get involved in plea negotiations and can't do anything to really try to convince the state to do that. And what happens, committee members, when we have a situation like this, is we end up with some sort of perverse incentives. And what might happen a lot of times is, because of 301 is so beneficial for defendants, who again are often young, nonviolent, and we're not talking about people that are either going to prison or not going to prison. These are people that the prosecutor agrees to probation, or we have a plea agreement for probation. They're not a risk to the community. The probation and parole has agreed that these people are good candidates for community supervision. The only question is whether or not we're going to saddle someone with a conviction. And what happens is, because that's a favorable thing for defendant, a lot of times the state will offer a 301 and give their consent to a 301 where their evidence is weak, regardless of whether or not the person is a good candidate. So you could have somebody who's a great candidate where the state's evidence is very strong. The state might say, I'm not going to give you a 301 because I know if I go to trial, I'll win. But that's not really what the most important thing to factor in is for a 301. The 301 is, the person's lack of criminal history, their ability to do well on probation. Shouldn't have anything to do with the strength of the state's case. So you'll get a situation where, you've got someone who actually comes in and cooperates with law enforcement and confesses, admits it right away. I screwed up. I committed a crime. I'm sorry. And a lot of times law enforcement will say, this is your chance to confess and to and make things better for yourself and cooperate, and things will go better. Well, it doesn't, because they just made the state's case for them. And now you're trying to negotiate with the state for a 301. And the state says, well, we have a really strong case. So if you don't want to plead guilty and get a conviction, we'll just go to trial and we'll win. On the other hand, you might have someone who, doesn't deserve a 301, but the state's case is really weak and they're worried about losing at trial. And they'll say, hey, we'll give you a 301 so that your person will plead guilty and not subject the state to their burden of proof. And that person gets a 301. And maybe that person went in and told the cops, I'm not telling you anything, you can pound sand, but that person gets a 301 because the state's case is weaker. And if we remove this, the state's veto power, that will eliminate that situation. And, it's not as if everyone will just get a 301 then, or they'll be handed out like candy. The state can still object. We can argue in front of the court, but then it'll ultimately be up to the court, just like every other final disposition is up to the court, the appropriate sentence, whether probation is appropriate or not. And so, we also see things like a state offering a 301 if someone will waive their constitutional rights and say, hey, the stop in this case might have been a little bit suspect, and you might have had your Fourth Amendment right violated to be free from unreasonable searches and seizures. But if you waive that right and you don't file a motion to suppress, we'll give you a 301. Okay, well, that doesn't seem appropriate either. You should be able to defend your constitutional rights without having to ask for the state's consent to a 301. The other thing that happens is, and I'm going to try not to talk too long, I'll be fast, and I have a big schedule ahead of you, but there's no oversight and there's no factors, there's no guidelines. And so prosecutors are free to create whatever policy they want, and they can be totally disparate and different in different parts of the state. So I think in some parts of the state, you have a prosecutor who says, I'm not giving 301s to anybody for anything. I don't think anybody should get a first offender status. Whereas the county next to them says, I'll give first offenders to this person, but not this person. Or I'm going to draw a line in the sand for these types of crimes and these types of cases. And so it's different all over the state, and there's no guidelines, there's no oversight. And the prosecutor can just simply say, I don't want to. And they don't have to give you any reasons why or why not. But if you were able to go to a judge, both sides can argue, the judge considers the appropriate factors and either gives it or doesn't, just like in a 1037. At the end of the day, that's really all I have to say. I could give the committee 1,000 stories about my cases and different, sort of war stories and a human element. I think hopefully we will have a person later to talk about that sort of human element and what it did to their family to face a prosecutor who simply would not give a 301 in a case where a person had cooperated and had done everything well on bond and was a great community member and was not a risk to the community. And there really is no downside to a 301 because we are talking about people who are going to be on probation. And some of my colleagues have said it best. If you give someone a 301 and they screw up on probation, you could immediately send that person to prison because you have their guilty plea. And if they don't screw up, then they deserve the 301. Why saddle them with the felony conviction? I just think the 301 is a great program. It makes so much sense. there's so little downside. And I think that the final say should be with the judge, and we shouldn't have this bottleneck with the prosecutor's office.
Mr. Peterson, thank you. Any questions for Mr. Peterson? Mr. Peterson, do you think that someone who has successfully completed their probation term under a 301 should be allowed for expungement?
Yes, thank you, Madam Chairman. And I also saw Senator Kolb had a question as well. Yes, this wouldn't change anything as far as I know for expungement eligibility. The expungement is treated under a different section of the statutes. I think I can't remember, 7, 13, 15, or 19. Ms. Lozano might know better than I do off the top of my head, but I don't think it would change anything. You would still either be eligible or not according to those statutes.
Actually, if you receive a 301, you are not eligible for expungement. Fun fact.
Oh yeah. Okay. Well, I see what you're saying now. Okay. Yeah. And you know, that's one of the main benefits is to just, you know, if people ask you if you've been convicted, you can of a crime, you say no, and you can fill those questionnaires out that way. But I hadn't even actually thought about that, because most people who get 301s don't usually apply for expungement because they don't have to answer that they've been convicted of certain crimes. But I would love to change that as well too. Why not give people more options?
I thought you might. Senator Kolb, did you have a question?
I did, Chairman. Devin, I'd like to play a devil's advocate a bit here and ask you why trading the court over, say, a local prosecutor, why the court wouldn't have the same pitfalls and problems as you have explained happens locally with some, I'll say, arbitrary and capricious positions. Why would the court not have that same issue come up with them? I don't see where fundamentally, if you're looking at these two groups, they're that much different. They're composed of people. They have opinions. It may not be good some cases, it may not be appropriate, but that's what we have. So if you could elaborate on why you feel the court in itself would be the better arbitrator of what we're talking about. Thank you, sir.
Mr. Peterson, go ahead.
Yes. Oh, thank you, Madam Chairman. And thank you, Senator, for the question. It's a good question. And I don't disagree with you that, different judges will inevitably take different approaches to this. And judges in different parts of the state will probably be more favorable to give a 301, and others will not. And I certainly can't argue with that. But I think what's the most important is that, from the defendant's perspective, is that you have that opportunity to make your argument and to make your case. And district courts are obligated to when they sentence someone to under Wyoming Supreme Court case law and other standards, to consider the character of the defendant, whereas prosecutors are not under the current 301. And to me, it's just kind of like that final oversight in the system. And there will be discrepancies, but to just have that opportunity and to make your case to the court is really what seems appropriate to me. It's the same for, there's many times where the prosecutor thinks you should go to jail, and you're hoping not to go to jail, and you're trying to convince them for a plea agreement. And if they ultimately say no, they have to go to prison, then you have options with, you can enter a cold plea to the judge and take your chance with the judge. You could have a trial, but with any other sentencing or final adjudication type consideration, the final ultimate determination is with the court, and you have that chance, and you can both make your arguments. But with the way it is now, the state, and this, obviously the state has different institutional considerations than the court does, and I believe that the court has the most appropriate considerations to make this final determination, and everything that they're required to take into account.
All right, thank you, Mr. Peterson. With that, we're going to go to Mr. Barone, who I think is one of the longest serving, hold your question, Senator French, one of the longest serving elected county attorneys in the state of Wyoming from Cook County. Mr. Barone, welcome. We look forward to hearing your comments, so please introduce yourself to the committee. We look forward to hearing from you.
Hello, thank you, Chairman Nethercott. That is true. I've been elected since 1990, and I'm a county and prosecuting attorney, elected since 1990 in Crook County, Wyoming. I went to high school in Moorcroft. I went to the University of Wyoming, Casper College, went to law school there at the University of Wyoming as well. I want to speak to the issue, and I think Senator Case said it correctly. This is a policy issue for the legislature to decide on whether or not the executive branch of government will have any say in a criminal defense decision, and whether it will accede to one branch of government, the courts, to have total control over this particular issue. Mr. Peterson raises a lot of issues that come up about one chance, mean prosecutors, the whole works. And believe me, over the course of the last 30 plus years, I've heard every one of these arguments from people that should have been in the pen, that shouldn't have been in the pen, and made decisions on 301 prosecutions and things like that. And so, there's always a case, and there's always there. And I think one of Senator Kolb hit it. It's like, who should be making this decision? Are we going to leave it to, as it stands right now, 3 people make this decision: the defendant, the state, and the judge. Any one of those 3 can veto this. So this is not a one-time veto by the prosecutor. A defense attorney can veto this. The defendant can veto this. And you might ask, why would a defendant do that? Well, frankly, because they're saving up. A deferred can be used in the circuit court for crimes there. And we see that happen, particularly on DUIs. You have somebody gets their first DUI when they're like, 65 years old or something. They've never done anything wrong in their life, even a traffic ticket, and that happens, and people get that and they use that. But then other people will use that, and they're like, well, it's a conscious decision to be made that they determine they're not going to do it. They're going to save it for perhaps a later time when they might be able to use that. And I've been a part of those conversations. I've talked to defense attorneys over the years, and that's a particular decisions that people make. So a defendant, it is in their interest to weigh that as well as to whether or not they get that and can use that. The second thing is the question came up is who's accountable for this decision? Okay. Defendants are never accountable, and they want to get out of everything. I mean, that's the question is, as a prosecutor, what do? We hold people accountable. The courts will do nothing unless a prosecutor brings a case to prosecution and has somebody convicted in that particular case. And so the prosecutor is more likely than anybody in the room to know more about the facts and the evidence in the case and about the particulars of a particular case and whether or not somebody is deserving of, quote, a deferred or a first-time status, and that there's some hope that this is just an aberration and this is not going to be a course of conduct throughout somebody's life. But the point is that who's accountable? Who's accountable in that room? The defendant certainly isn't. The county attorney is an elected position. It's elected by the people in each particular county. Those, as an elected official, I have to answer every 4 years to the people, just as you do, to the people on the decisions that I make and the recommendations that I make in court and otherwise. And, we prosecute, most of the people here that we prosecute are local. And so I have to deal with that every election, every day, every time something comes up in that particular case. Now, you might think that judges are elected. No, judges are retained. Nobody actively runs against a judge. They are retained, and if they get a majority of the votes cast in that election, I believe, they are retained in that particular matter. So it's a big difference as to who is more accountable to the people that they serve. And we're a part of the executive branch of government, and we're a co-equal branch with the judiciary. We're the ones, frankly, in that courtroom that do most of the work. And the judges are there, they see the person in a snapshot of time in that half an hour setting that they have a sentencing hearing there. And they are making that decision. We obviously, in the 1037s or whatever they are, have a chance to object. But in this case here, each one of the three that are in that courtroom have a chance to object or not go along with the deferred. The other thing is that, and Chairman Nethercott brought it up, when this law was passed and it was significantly, the state's quote veto power was added, it appears to me in 1987 under the law. This law has been in existence, or parts of it, since 1909 on that. But since that time, the legislature has granted expungements of criminal records in almost every case except for violent felonies, both in misdemeanor cases and in felony cases. That didn't exist back when this law was created that gave the state this authority. The other thing that the legislature has done is that you've had passed the laws for automatic restoration of rights, people's voting rights. And you've passed that as well. So the consequences of all of this are not as egregious as is being presented in this particular case. There are other remedies for folks that exist if the overzealous prosecutor decides to veto this at that particular thing. Now, when we get down to get right down to it, the executive branch is the one that's closest to the people. The judge is supposed to be neutral and detached on that. And that's where they need to be. They need to let the county and the prosecutors do their job. And Mr. Peterson is absolutely correct. Deferred prosecutions are used as a tool in plea negotiations. I get it from defense attorneys on almost everything. You know, can we do this? Can we do that? Whatever. And a lot of times it's not appropriate. But that doesn't mean that they still don't ask the question when that comes up. But the state should always have input on whether or not a conviction is deferred. And frankly, if you veto this, if you take this clause out, that would allow courts to grant deferrals after trials when somebody's been convicted after a trial. Now, one might say that, well, Mr. Prosecutor, what you're doing there is you're punishing me for exercising my right to go to a trial. No, that's not the way I look at it. The way I look at it is this, is that admission is the first step towards rehabilitation. And if you're willing to admit to your crimes and you go in and you plead guilty, then that's one of the number one things that there's actually a chance that this person is going to be rehabilitated and is worthy of getting a deferred in that case. And the other thing is the arbitrariness guidelines, none of that stuff's going to go away. If somebody thinks, just because somebody thinks it's arbitrary because it's different in Crook County than it is in Campbell County or the other side of the state. Okay, so we have 23 elected officials making that decision. And when I don't know how many district court judges there are, but I've got 3 of them. And so all 3 of those judges are different on how they act. So you're going from even a more inconsistent method when you leave it up to the courts to decide those things. Plus I have another judge, I have a circuit court judge. I actually have 4 judges that I practice in front of routinely, and every one of them is different on everything. So moving it from one realm to another doesn't change that arbitrariness, or at least perceived arbitrariness on that. Thank you.
Thank you, Mr. Barone. Any questions for Mr. Barone? We've got some very powerful lawyers in this room right now. I really appreciate both of you being here. I think we have some more testimony. It looks like we have Mr. Jeff Stanberry, another University of Wyoming College of Law graduate, and most notably, Riverton High School.
Can you see me?
Go Big Red. Welcome, Mr. Stanberry. Please introduce yourself to the committee.
Thank you, Madam Chairwoman. I appreciate your willingness to allow me to speak today, and thank you for the introduction. I hope everybody can hear me. I know sometimes these Zoom meetings are difficult, and whether our web browser and everything or our internet bandwidth is going well is always an issue.
We can hear you fine. So go ahead and introduce yourself with your name and what you do and your testimony.
Great, thank you. My name's Jeff Stanberry. I am an attorney here in Fremont County. We have offices. I'm partnered with Catherine Strike in the firm of Stanberry and Strike PC. We have offices that practice an office in Riverton and Lander. And Fremont County is a larger county. We have 2 circuit courts, 2 municipal courts, and 1 district court. Additionally, at times we can have judges assigned from in the 9th Judicial District from Jackson and Pinedale. I want to commend Senator Case, who's my local senator, for bringing this bill and sponsoring this bill, and Mr. Peterson, who has given some fantastic testimony today as to its considerations. I have practiced in this county for approximately 16 years and practiced in the realm of criminal law. And one of the best, I would say, tools available to criminal practitioners, and that includes both the state and the defense and the courts, is the 301 statute. And I think Mr. Peterson did an excellent job of explaining the 301 statute, but I just want to clarify some of the details because of the testimony regarding accountability. The mechanism for a 301 essentially is, I explain it to my clients as this. Essentially, you either plead or are found guilty of a crime. And rather than having that guilty plea entered and conviction entered, I explain it that it's as though you sign a written piece of paper that says I'm guilty. The court would put it in the file, hold it in abeyance, defer entering conviction, and place that person on a term of probation. Whether that probation is supervised, unsupervised, whether it's 1 year, 3 years, that's up to the court and the parties involved. If the person is successful on probation, then that guilty plea essentially is the metaphor I use, is that it's tore up and the case is dismissed. And on their criminal record, it shows that there was an arrest, but it does not show conviction was entered. It shows dismissal pursuant to 713-301. If the person is unsuccessful, the court and the state have a variety of ways of dealing with that. And that is they file a motion to revoke their probation, and the court can then enter conviction and proceed to sentencing without a trial. Now, obviously, that circumstance is different if the 301 is granted after trial. The reality of the situation and the practicalities of the situation, I have to disagree with Mr. Barron in that I understand what he's saying. He makes a very good point that pleading guilty and taking accountability for your actions should be a central factor in terms of being given this opportunity. But that finding is still available to the courts, and the likelihood that a court grants a 301 is slim if somebody goes to trial, because I agree, taking responsibility for your actions is a central factor. But here's the thing, and this is why we are here today, essentially. The 301 is a tremendous opportunity for a defendant. Our legislature a long time ago had decided that people make mistakes and they are human, and we should give folks an opportunity to try and see if they can rehabilitate themselves and show that they can be successful without burdening them of this conviction, whether it's a misdemeanor or felony. It essentially makes them ineligible for violent crimes, felony level violent crimes. And affords this great opportunity. Now, what's fantastic about the 301 is that it gives the court, the state, the defendant, the opportunity to present the defendant with both the carrot and the stick. If a defendant is simply convicted, there is only the stick, and that's the notion of staying out of jail, being fined, things of that nature. But a 301 enhances what the conduct of what a defendant may do by saying, if you jump through these hoops and if you rehabilitate yourself or whatever conditions are imposed upon a defendant, it gives them incentive to go ahead and make themselves better. And when a court examines defendants and decides how best can we first punish the person, second, deter future conduct, and third, rehabilitate them and protect the community, I think there's a very big interest in trying to both make the defendant go through these requirements and successfully rehabilitate this person so that our community remains safe. If it's only a stick, I think that incentive is watered down a bit. But when there is a carrot, like having the possibility of eliminating the conviction, there's a lot of incentive for a lot of defendants to go ahead and work through these hoops to make themselves a better person and demonstrate to the community, the court, and the state that they can do this. And this was a blip on the radar. Secondly, I know Mr. Peterson touched on this, the equal treatment within the state. I live in a jurisdiction currently where if you get a DUI with a 0.15 or greater, the 301 is available to you through the county attorney's office because of the line that they've drawn, depending upon which side of the river that you get arrested on. Yes, and I want to speak to this in just a second. Senator Kolb's point, isn't that arbitrariness still present with a court? And there are some differences, but in essence, what I think our goal is to make sure that similarly situated defendants are sentenced and treated similarly and handled similarly for similar crimes that are committed under similar circumstances. And right now, there is a distinct arbitrary nature to that, as Mr. Peterson said. The difference between removing it from the state and to the courts is that once it goes into the courts and the defendant is able to present that argument to a judge, the defendant has certain due process rights to go ahead and make the case to the court that they are a good candidate. The defendant can subpoena witnesses, the defendant can subpoena documents, and the defendant can present evidence as to why they are a great candidate. The defendant can call their counselor and demonstrate and their employer and tell the court and illustrate to the court why they're a great candidate. These due process rights are not available if the state is given a veto power. Secondly, the veto power makes the 301 susceptible to political pressures. I understand and agree with Mr. Barron that yes, they are elected officials and they are accountable to the public, but in many respects, that really works against the 301 because you're making decisions based upon that political nature, maybe not what is best or tailored to the defendant. And I have had prosecutors tell me, Jeff, I think your candidate's a great candidate, but the public's going to crucify me if I give them a 301. I think they can succeed. I think that they can accomplish this. And in that respect, I think that the mechanism and the public is better served to allow the state to go in, argue to the court why they should not receive a 301, allow the defendant to argue why they should receive a 301, and let somebody who is not an elected official make the determination after hearing all of the facts presented in a cogent and coherent argument, make the decision whether the candidate should receive the 301. I have to strongly disagree with Mr. Barron that the only person accountable in a 301 circumstance is the state. The defendant is by far the most accountable person in this 301 scenario. Why? Because, especially in the guilty plea scenario, the defendant has agreed to forego those rights, enter a guilty plea that the court holds in abeyance, And if the defendant violates the term of probation, they can be sentenced without trial, and then they can go to jail. The criminal penalties are still there, and nothing has been lost. As I said, the carrot is present for the opportunity to get rid of that conviction, and the stick is still there from the punishment perspective. Finally, I have had prosecutors who, we live in small communities, and the notion that a good old boy system does not still exist, I think we'd be naive to understand that. Knowing certain candidates has affected prosecutors' decisions, and it still does to this day. Not knowing certain candidates has affected prosecutors' decisions in granting these 301s. We need to evaluate these defendants based upon the characteristics of their background, the circumstances and facts pertaining to the crime with which they've been arrested, and how effective this rehabilitative provision and timeframe may be for a defendant. But let's trust our judges. I think we vet our judges in an awesome way. We have a judicial nominating commission. The governor then selects the judge from the pool after extensive interviews for these qualified individuals to make these decisions after hearing all arguments. I think that is, in essence, what I wanted to say. I apologize if I was long-winded, but I can't tell you how much I appreciate the opportunity to speak in front of you today on this really important law. And I really think we can alleviate the pressures on our system and save this state money if we allow all parties to go in front of a court and argue that a defendant is an appropriate candidate for a 301. Thank you very much, Madam Chairwoman.
Thank you, Mr. Stanberry. Now I know how my colleagues feel when they hear me talk. It's a lot of oral argument coming at them very fast with a good closing argument. A quick question for you, Mr. Stanberry. If this bill were to pass, at what point in the process would you have your client plead guilty? Are you asking them to go to court and do a plea of guilty to the court at the same time asking for a 301 as opposed to having the guarantee of the prosecutor?
I think the way that I view the 301 statute, Madam Chairwoman, and the way that it's written, I think that if, in order for the court to gain jurisdiction to grant one, you have to be representing that the person will plead guilty to the crime in order to enter it and receive the benefit of the 301. Now, as a practitioner, and in terms of what would be best for a defendant in terms of being granted, I would rather, and Mr. Peterson actually may disagree with me on this notion, I would rather eliminate state consent and eliminate having been found guilty than having been found guilty present in the statute and maintaining state consent. And the reason for that is there is a policy that Mr. Barron spoke to about taking accountability for one's actions. But when someone is willing to take accountability and plead guilty and say, I will do whatever I can to show the community that I can take responsibility, I think that we should at least be allowed to make that argument and then withdraw that guilty plea under Rule 11 E1C, I believe, if that is not afforded to them. But that, I guess, I don't know if I answered your question there, but.
Mr. Stanberry, I think my point is, I think it's pretty risky what you're actually asking on behalf of your client. And I don't know how the court would get jurisdiction of a person without getting a conviction or with a guilty plea to put them on supervised probation for a period of years on a deferral basis. So I think without a written plea agreement or an agreement with the prosecutor's office, you're walking your client into the courthouse, having them plead guilty, and throwing yourself on the mercy on the court for a 301.
I do agree with you, but we do that in virtually all cases where we're arguing for a sentence. We, as defense attorneys, are at times only offered a cap argument, and it's our jobs as defense attorneys to calculate that risk, adequately explain that risk to our clients. We do that in cases where there's an agreement between the state where we cap, say, we'll cap a punishment at a 5-year cap, argue below that, or concurrent versus consecutive sentencing. That still exists without that 301. I think the job is to eliminate the risk, minimize it, and adequately explain that to our clients. And then if they choose to go to trial, that's what we do.
Thank you, Mr. Stanbury. I would distinguish between a sentencing argument as opposed to a plea of guilty argument at the same time. So I do think it requires and merits further thought on all of our parts. With that, are there any questions from the committee for Mr. Stanbury? All right, thank you. Oh, Ms. Lance, I see that you're here as well. Welcome to the committee. If you would introduce yourself and share your thoughts with us.
Thank you, Madam Chairwoman, and hello to all the members of the committee today. I am here today on behalf of the Wyoming Trial Lawyers Association. I am also an attorney. I practice in private practice in Cheyenne, and I too practice criminal defense and have a background as a public defender. We stand in support, our membership is in support of this bill. I don't want to belabor too much many of the points that both Mr. Stanbury and Mr. Peterson have already made were well taken, and certainly we are supportive of those points that were made. I agree with Mr. Barron as he stated that prosecutors often know more than judges, obviously, when they walk into courtrooms about defendants, about the crime that may have been committed and what's happening in the case. Certainly that is well taken. This amendment to this statute for the deferral certainly continues to take that into account. The difference would just be that the prosecutor and the defense attorney would both have the opportunity then to explain what they know and what they believe is the situation and whether someone is or isn't deserving of a 301 deferral treatment, and leaving it then to the court's discretion rather than allowing the prosecutors to be the gatekeepers to an opportunity for a 301 deferral. Also, Madam Chairwoman, your point is well taken as well. It would certainly be a risk for a defendant, I believe, to come into a courtroom on what we call a cold plea, which would be when you don't have an agreement specifically for the sentencing that you expect to request to the court. So this doesn't preclude, however, an agreement. So this also would still allow for the defense attorney and the prosecutor to agree that they will still go into court and say, we both agree this person deserves the deferral treatment in this case and that a 301 should be applied. So it doesn't preclude that from happening. I would expect that hopefully that would continue to happen on a regular basis. However, in those communities of which I also practice, in a community where there has been a prosecutor who is elected who has made a declaration of not ever allowing in certain situations any 301 treatment, regardless of the facts that exist in the case, it just at least gives a potential opportunity for a defendant to make a decision whether they want to risk that, whether they want to just go in front of the judge and make an argument for why they should deserve a deferral treatment. And that's what this statute allows. If you are to pass SF 49, it would allow just, I think, the opportunity that already exists within our statutes under 35.7, 1037, which is a deferral that's specific to possession of controlled substances. And that has already operated for years without a, so to speak, veto power of a prosecutor, and has worked well. And so I think this would just be a change that would be in line with that type of deferral. It would just, this would open it up to other specific offenses besides just possession of substances. And so with that, I would take any questions.
All right, thank you, Ms. Lance. Questions for Ms. Lance? All right, seeing none, For those in attendance, if you would raise your hand if you'd like to speak. Looks like we have Director Lozano. Ms. Lozano, please come in. We are going over time based on my expectation for this bill, and it's because of the lawyers. There's just so many. I know you're at the end here and you have a lot to offer to this conversation, so we do look forward to hearing from you, but just be mindful that we're running short on time. So if you would start your camera.
Can you hear me, Madam Chairwoman?
We can hear you, yes. So if you would introduce yourself to the committee and share with us your thoughts on the bill.
Thank you. Diane Lozano, Director of the Office of the State Public Defender. I've been with the Public Defender's Office since 1994. I've done nothing but criminal defense. I've been the director of the agency since 2007. Thank you for giving me a few short minutes. I don't think I can add much to the conversation after listening to Mr. Peterson, Mr. Barron, Ms. Lance, and Mr. Stanberry. I mean, I think they've covered it. I would just tell this committee that, you know, my attorneys handle on average 90% of all criminal cases in the state every year. And anecdotally, we would tell you that the criminal justice system would be far more efficient in terms of moving cases through the docket if courts always had the option to consider first-time offender status for our clients. I think it's concerning that when we have a system that's designed to allow for individualized sentencing through the 8th Amendment, that prosecutors get to eliminate that option for the court across the board. I think it's important to note and to emphasize a little bit of what Mr. Peterson said, that it really depends on what county you're in. And I can't imagine a more arbitrary and a capricious aspect to a system that isn't supposed to have that. For instance, you might not get an opportunity to get a deferral or a 301 opportunity on a DUI in Laramie County, but in every other of the 22 counties you might. And so it depends on where you made your decisions and where you got caught and whether or not you could be held accountable. I think that it is a tool that has become politicized. And I think prosecutors should have some political power. That's their job. They are elected officials. They get to decide what the charge is. They get to decide in a first-degree murder case whether or not the death penalty is an option for a jury. But how we temper that, and really I think in an answer to what Senator Culp said, is to have somebody who's insulated from that system make the final decision. And ultimately, in my experience, if I have a client, whether it's a young client who's made a terrible mistake or somebody who's older, who's never been in trouble and all of a sudden finds himself in a situation where he could end up with a felony conviction, I think having the opportunity to argue to a judge without a prosecutor eliminating that option for him and for the court actually encourages accountability. And I would agree that it's a risk, but it's a risk I take every time I advise someone to give up their right to trial. It's a risk that they take every time we go before a judge because the judge ultimately gets to decide. You know, I think we have a pretty good criminal justice system in Wyoming. I don't think eliminating consent for prosecutors changes much, except that it just says to the prosecutors, it's not your decision wholly and solitarily without any oversight whatsoever. My attorneys would tell you that they'd love to be able to argue it when they think it's appropriate. I would disagree that we would just ask for it in every case. We know better. We know which cases are amenable to probation and which cases our client should be going to prison on. And I think that we would be fair judges of who we should be asking should be treated as first offenders. And like Mr. Stanberry said, I think our judges get it right most of the time, if not 100% of the time.
Director Lozano, thank you so much. Questions for the director? Committee, I just want you to recognize that we have two attorneys in front of you, Mr. Barone and Director Lozano, who have decades of experience in the criminal justice system in Wyoming, and there's probably no two other lawyers in the state that can bring the level of expertise in front of you today. So we're very fortunate to have you both and appreciate you here and all that you've done in service to the state of Wyoming, making sure that our criminal justice system is one of the best in the country. So with that, it looks like we have Ms. Judd available as well to speak on the bill. Welcome, Ms. Judd. If you would introduce yourself to the committee.
Good afternoon, Madam Chairwoman and committee members. Thank you for giving me the opportunity to speak. As you said, my name is Isley Judd, and I'm joining you today to offer you the perspective of someone who has been impacted by the state consent requirement of the current deferred prosecution or 301 statute. I'm speaking about a fairly recent Fremont County case involving my brother, and the frustration and disappointment that he faced as a defendant and that we faced as his family and his support system as we explored his 301 eligibility. By way of background, my brother was arrested in July of 2019 and charged with 1 count of conspiracy to deliver a controlled substance, which is a felony level offense. And at the time of his arrest, my brother immediately cooperated with the detectives assigned to his case. He candidly discussed with them the details of the incident that led to the charged offense. He disclosed the nature and extent of his own substance abuse problems. He provided information on known participants in the local drug scene. He facilitated access to his cell phone so that the officers could review its contents. And he did all of these things in the hours immediately following his arrest without ever consulting a lawyer. And he did that in large part because he was repeatedly assured by the detectives on his case that his cooperation could engender a more favorable outcome for him. Subsequent to my brother's arrest, our family consulted several defense attorneys, and each of them raised the possibility that he might be eligible for the deferred prosecution pursuant to Section 301. And early on, these discussions arose because my brother very clearly met the basic requirements under the letter of the law. He was charged with an eligible offense, and he was a first-time offender with a completely clean record. But over the course of the 9 months that followed between his arrest and his sentencing, it became clear to those around him that he also deserved consideration for 301 status under the spirit of the law. My brother was released on bond the day after his arrest, and he immediately demonstrated a commitment to his sobriety. He stopped using all drugs and alcohol and disassociated with anyone who would be detrimental to his recovery. He became very reflective on the nature of his drug addiction, on what choices and circumstances had contributed to his addiction, and on how he had allowed his addiction to spin so out of control. He independently sought a substance abuse evaluation and began seeing a therapist. And by the time of his sentencing, he was nearly 9 months clean and sober. My brother was and continues to be a committed business owner, providing an essential service to his community. Despite his arrest and the stress of the charges pending against him, he was dedicated to keeping his business alive. And he continued to be a fully competent, engaged plumber who was generous with his time and skills, particularly to the members of his community facing financial hardships. Numerous community members who had engaged with him personally voiced full-throated support of him via letters to the prosecutor who was assigned to his case. My brother was and continues to be an active member of his community. He was known for volunteering his skills and time, organizing local leagues and events, coaching middle school sports. These are only a few of the ways in which he impacted the people around him. And these efforts were certainly not lost on his community. In anticipation of his sentencing, more than 50 letters of support poured in on his behalf. They came not just from his family and high school buddies, but from parents in the community, teachers, local business owners, and other well-respected members of the community. These and other factors all really seem to indicate that my brother could be a serious contender for deferred prosecution, but unfortunately he was not. From the outset, the focus of his case resolution seemingly had nothing to do with his personal character, his lack of prior contact with law enforcement, consideration of past trauma, or an understanding of substance abuse and rehabilitation. Rather, the focus was on how easily his case could be proven at trial on account of the very candid and honest statements that he had made to the detectives on the day that he was arrested. Prosecutors associated with his case showed no interest in reading the letters of support that were submitted on his behalf, despite the staggering number of them. Similarly, they exhibited no interest in hearing about his past trauma, such as the fact that he had witnessed the death of a friend during a hiking trip, or that he had suffered severe mandibular and facial fractures during a sporting event, and whether these situations may have contributed to his reliance on drugs and alcohol. Seemingly, every discussion of deferred prosecution circled back to the fact that the state did not need to consent to a 301 because they believed they had the evidence necessary to succeed at trial. It was quite simply a bargaining chip, and we were not in a negotiating position where they felt like they needed to use it. We watched as other defendants who were arrested on similar charges, people with past misdemeanor convictions who seemed, on the surface at least, certainly less deserving of consideration, but who had not been as forthcoming with law enforcement, received deferred prosecution offers. And for us, that was extremely disappointing. It was extremely frustrating. We quickly came to realize that the merits of the actual defendant mattered far, far less than the strength of the case file. So after 9 months of hoping that the state would consent to the 301, my brother ultimately pleaded guilty to delivery of a controlled substance, which is a felony offense. And the judge in his case sentenced him to a probationary period of 1 to 2 years with a suspended custodial sentence of 4 to 6 years. Given his impeccable behavior on probation to date, including completion of various substance abuse programs, we anticipate that he'll be discharged shortly after serving 1 year of probation. So as a family, I have to say that we are incredibly grateful that the criminal justice system stepped in when it did. It sparked him to get clean and to seek the help that he needed to stay clean. We're also very grateful to the judge who presided over his case for sentencing him after fully considering my brother's character, his commitment to sobriety, his contributions to his community. And with all that said, we can't help but wonder whether, given the opportunity, that same judge might have deemed him worthy of a second chance afforded under the 301 statute, thereby easing him of the burden of being labeled a felon for potentially the rest of his life, certainly the foreseeable future. Already his status as a felon has affected his ability to be eligible for things like small business relief under the COVID relief programs. It has influenced his business and employment decisions, and it may very well prevent him from ever again coaching a high school or middle school sport. So I guess in closing, I would just say that even with the proposed changes to the statute, there's clearly no guarantee that my brother's case would have ended any differently. We could have lobbied for the 301, the prosecutor could have voiced his opposition, and the judge, after reviewing all of the evidence and testimony, could have ultimately decided that it wasn't appropriate under the circumstances. But from the perspective of people actually going through the process, just knowing that a neutral arbiter had reviewed all of the available information and used it to reach a reasoned, objective conclusion would have made a difference to us. It would have been far preferable to our situation where the state looked no further than the strength of its own case before foreclosing the judge's ability to even consider deferring prosecution on the basis of both the facts of the case and the merits of my brother as a person. And because of this, I would encourage you to amend the current statute to empower the Wyoming judiciary to make deferred prosecution determinations, even in the absence of prosecutorial consent. So thank you for your time.
Ms. Judd, thank you so much for sharing your story, your family story, and your brother's story. We appreciate hearing from you. It helps us make informed decision-making and understanding how these laws affect real people in Wyoming. Are there questions for Ms. Judd? Ms. Judd, thank you. When was your brother convicted?
His guilty plea was entered, I think it was April of last year. It got scooted forward a little bit because of the COVID shutdown, but I believe it was in April.
Well, it looks like soon enough he should be eligible for an expungement, where he would not have been had he received a 301. And so he actually can be free from that felony conviction as a result of not receiving a 301. So maybe a blessing in disguise. Thank you, Ms. Judd.
Thank you.
Committee, any final questions for some of the panelists you see in front of you? You've got some expertise to help you make this decision. All right, back to you, Senator Case. Any final comments? Again, we're about 40 minutes over where I thought we'd be, so I'd ask you to be very, very brief.
Madam Chairwoman, I'm very grateful for the testimony of all the presenters today and for your patience. And I think you've all heard enough.
All right, thank you, Senator Case. With that, public comment is closed. Committee, we're coming back to you. Committee, what's your pleasure on this bill?
I would move the bill.
Moved by Senator Cost. Is there a second?
Second.
Seconded by Senator Cooper. Checking with our Senate staff. Do we have Senate staff who's able to track this, making sure she's okay, can hear us? If not, Ms. Creech, are you able to follow along?
Can you hear me now?
We can hear you. Wonderful to see you.
Online, thank you.
Great. So we have Senate File 49 has been moved by Senator Cost and seconded by Senator Cooper. Discussion on the bill, committee. Senator French.
Yes, I'm opposed to this. You know, we have 23 different counties out there, and we have elected county attorneys that represent the norms of those communities. Now, the community, the norm in Niobrara County, Lusk, could be very different than Teton County and Jackson. Or the norms in Powell could be very different than the norms in, Park County than in Laramie. So I don't think we should take away from those county's attorneys that answer to the people in their community any of their authority. Thank you.
Thank you, Senator French. Senator Kolb.
Thank you, Madam Chairman. You know, I've been around a few judges in my time, especially being a commissioner. I'm sure Senator French has seen quite a few in his time. I can tell you one thing that's a fact. You can outvote a county attorney, and you don't get a chance to vote for another judge. So because of that, I'm really taken back on the idea that the judge is somehow a better arbiter of the outcome of said, in this particular case, a 301. I don't see where that's different. I have not heard any testimony that said that the judges are inherently blessed with other Superman-like abilities. They're men or women, just like county attorneys are men or women. And with that, I don't see what the difference here is. I think maybe there is something to be said about possibly another way of doing this. But in this particular case, I think I'd rather stick with the devil I know than the devil I don't. And I'll say it like that, not in a disparaging way, but in a factual way, is we're dealing with people. And all I've heard is someone's going to do something differently because, well, they're not like a particular county attorney. Well, that may be true in some cases, but not in others. So I don't know why we're making a decision here that is improving the situation. It's just changing who's going to make that final outcome in my mind. And I don't know why that's a thing that I would be supportive of. Thank you, Madam Chairman.
Thank you, Senator Kolb. Senator Cost.
Thank you, Madam Chairwoman. You know, and I'm going to take the other side, the good senator from the Green River area is taking in the Rock Springs area, and say that not only are there chances for the judge and the prosecuting attorneys, but kids make mistakes, and it's probably going to be geared more at kids than anybody else. That first time offense can come back to haunt you, and if you can't get rid of it, it really is a difficult thing to try to remove, and expungement's not always an easy answer. I think sometimes in our courts we need to look at is there a way for a break? I can go back to 16 years old, pulling out of the A&W root beer stand in Basin and when I went to my physical for draft, the Army could not understand why you'd get a reckless driving with a $14 fine. And they fought and removed it, which was surprising to me. And I was a 16-year-old kid that didn't know what in the heck was going on, but I knew I was going to be in trouble when I got home. I think sometimes a break needs to be there. And I think the way this is set up with first-time offenses and all, it has merit for those people that fit the identity. Thank you.
Thank you, Senator Cost. You won't be driving to lunch the next time we all go. Any comments, Senator Cooper?
I'd have to agree with the 16-year-old driver. I run across a lot of young adults in my business that have made some pretty serious mistakes, some misjudgments that are haunting them through life. And if they'd had the opportunity for that second chance, it would have changed their course. I'm quite sure. I think the fact that we know that there are certain county attorneys who have set a hard and fast rule, there'll be no 301s, is rather disappointing to me. I think in the interest of uniformity, we should take them out of the decision making. And I agree that nearly all of them are great people, really dedicated to their jobs, but all it takes is one to abuse the system. And I'd like to take him out of that system. So I think I would speak for and in behalf of the bill here.
All right, thank you, Senator Cooper. Any further discussion on the bill?
Question?
All right, with that, roll call vote on the bill.
Senator Cooper,
Aye.
Senator French,
No.
Senator Kolb,
No.
Senator Cost,
Aye.
and Chairman Nethercott.
I'm an aye to get it out of this committee. I'll be a no vote on the floor, but not for the reason that people think. I do believe that this issue needs further discussion and further understanding of all the lawyers in the state. I think there's a lot to work through there that's not understood by either side. And so I'm an aye vote now. I'm a no vote on the floor.
Thank you, Madam Chairwoman, and thank you, members of the committee. Appreciate your time today. Take care.
Okay, with that, good committee members, we're going on to Senate File 6, a bill that we have worked before, public contracting works. And committee, this is one that we don't have anyone to necessarily explain the bill. It's a joint judiciary bill. And we are short for time, so I want to work this fast. And I know there's a lot of stakeholders involved with this bill. So if we could go ahead and let some of those folks in. I know we have Wyoming Contractors Association. I think we have Representative Stith also available. If we can pull Representative Stith in, who really spearheaded this when he was a member of the Joint Judiciary Committee this last interim, and is a proponent of the bill. Wonderful. Looks like we have most of the major stakeholders in. Representative Stith, it's great to see you. I'm going to have you stand by. I would normally start with you and recognize you, but we are significantly delayed. I had anticipated that previous bill lasting about 30 minutes. So here we are. I'm going to start with Ms. Legursky. Again, committee, this is a bill that we worked previously already and tabled it. during this last temporary session that we did, so that we could spend more time and have the stakeholders get together and maybe come up with some compromises and allow the new members an opportunity to really study the bill. And so we won't belabor walking through the bill again. And instead, I'm going to go ahead and start with Ms. Legursky to tell us about maybe the work that the stakeholders have done on this great bill. So Ms. Legursky, welcome back to the committee. If you would introduce yourself and share some of the progress that might have been made.
You bet. Thank you, Madam Chairman. I'm Katie Legursky with the Associated General Contractors of Wyoming. And following the last committee meeting, I did sit down with Jeremiah Riemann with the County Commissioners Association, as well as Bob McLaurin with the Wyoming Association of Municipalities to work out a couple of issues. We did come to agreement on a number of things, and I did share that amendment with the chairman. And very quickly, what the amendment does is that on the section on the beginning, the very end of page 4, first part of page 5, where we talk about transparency, we did add an amendment in there that after page 5, line 2, we inserted after shall make available to the public its rationale or provide a report to the Department of Transportation or to the State Construction Department. When we're talking about public funds, using those funds for public work projects, we believe in full transparency that a contractor or anybody else should know why the public entity decided not to use the low bid. We also then did a number of other amendments to make it so that the city, towns, and counties can come up with their own pre-qualification process rather than using the Department of Transportation's or the State Construction Department. And those amendments are on line page 5, line 7. After we inserted the counties, cities, and towns. On page 5, line 12, after by, we inserted the county, cities, and towns pursuant to statute 24-1-132H, page 9, line 1. We inserted H, adapt uniform rules for the pre-qualification of bidders on contracts for public works as provided in Wyoming statute 16.6-119B. And the final amendment we agreed to was on page 11, line 13. After that, we inserted cities, county, cities, and towns, comma, the. So basically what our proposed amendment does is that it gives the public entity the option to make available to the public works its rationale instead of doing a report to the two agencies. And it also allows the city, towns, and counties to develop their own pre-qualification system. And with that, I'd stand for any questions.
Ms. Legursky, remarkable. Thank you so much. I appreciate that and your clear understanding of the amendment. Committee members, questions for Ms. Legursky? Everyone confirms that they have the amendment. I think we discussed this before we started. Make sure you had this proposed amendment. Wonderful. Mr. Riemann, I see that you're here, and Mr. McLaurin. This represents, I think, some compromises and work that the three of you did, both the Contractors Association, County Commissioners Association, and Wyoming Association of Municipalities. Is that correct?
Madam Chairwoman, for the commissioners, absolutely.
Great. I'm seeing a head nod from Mr. McLaurin from WAM. Is that correct?
Yes, ma'am. Yes, Madam Chairman.
Wonderful. We're going a little out of decorum here, but so it goes. Appreciate that, and appreciate that the work that you have done. With that, Representative Stith, are you familiar with the amendment?
Madam Chairman, yes, I am. And the only exception, well, the one exception I would raise to the committee's attention, I believe there's a proposed amendment on page 3, line 17 to delete the word reasonable. And I don't know if that's in the current version of the amendment, but I just think it's strange. I didn't think the county commissioners or the Wyoming Association of Municipalities was arguing for the right to be unreasonable. So it strikes me as an odd kind of deletion to make. With respect to the body or the real meat of the proposed amendment, which is on page 5, line 7, and again on line 12, I understand that that could be a reasonable compromise. What this does is on the one hand, the cities, counties, and towns could do something of an end run around the statute, but on the other hand, it would at least require that they have uniform rules that would be applied uniformly to all bidders. And so that, I think, is a step forward. And so for that reason, I really appreciate the work that Mr. McLaurin, Mr. Riemann, and Ms. Legursky have done to get us to this point. So the only other comment I have is, I believe Mr. Brubaker had raised at the last meeting an issue with respect to airport boards. And I don't know if there's been proposed language about that. I don't know if it's useful to talk about that, but I was just quickly ginning up, if you don't have potential language, I thought you could add a subsection E, which would be on page 6, starting at line 7. If you haven't already got language, something like, you could say, the requirements of this section shall not apply to airport boards as defined under Wyoming Statute 10-5-202 to the extent that such compliance would conflict with applicable federal law, rules, or regulations. So that's just if the airport boards were concerned that this was going to get them in conflict with the FAA, then I think that carve out might be appropriate. Other than that, I really appreciate all the hard work the committee has done. I think this is a great bill because it really deals with 3 solid issues that are listed on page 5 and over onto page 6 that make for a level playing field. And really, the whole goal of this is to save taxpayer dollars, right? Because you make sure that the bidders, that all of the genuinely qualified bidders can bid, and that's a savings to taxpayers. So I think this bill has a real benefit to the public. So does anyone have any questions for me?
Thank you, Representative Stith. Questions for Representative Stith? Mr. Riemann?
Madam.
I actually welcome this conversation. This is a pretty technical bill, and all of you have worked on the technical aspects of it and want to make sure we get this right. So I am comfortable kind of going out of our normal methods of decorum in order to make sure we do that right now. So welcome, Mr. Riemann.
Thanks, Madam Chairwoman, members of the committee. Just quickly, I wanted to not ask a question, but just to respond to Representative Stith relative to the change proposed on page 3, line 17, to remove reasonable. If my recollection serves me, that's actually something that the contractors themselves brought forward as a proposed change, not because the cities, towns, and counties want to be unreasonable, but rather because of the multiple interpretations of what reasonable or what constitutes reasonable could be. And so simply striking that language was something that we were agreeable to as part of the discussions.
Thank you, Mr. Riemann. All right, committee questions for County Commissioners Association, Mr. Riemann, Wyoming Association of Municipalities, Mr. McLaurin, Wyoming Contractors Association, Ms. Legursky, or Representative Stith. Don't be afraid to ask questions because we're short on time. So I really do want to work this bill thoughtfully. So with that, I'm going to ask all of you to still stand by, and we'll go to Mr. Brubaker from the Air Boards. Mr. Brubaker, welcome back to the committee.
Thank you, Madam Chair. Appreciate the opportunity. My name is Devin Brubaker, representing the Wyoming Airports Coalition. I serve as the airport director at the Southwest Wyoming Regional Airport in Rock Springs. Appreciate Representative Stith's, good to see you on virtual world here. Appreciate his call out of airports. We have indeed presented or proposed amendment language to the committee. I believe the committee should be in receipt of that amendment language. And it's similar, however, it does not exempt us from any of the requirements. It simply puts us under the purview of WYDOT for the pre-qualification requirements. So we have a list of amendments. There's one amendment that deals with the transparency paragraph that was spoken about at length before, that I will partner, if it's all right with you, Madam Chair, and the committee, partner with Director Reiner on from WYDOT as we worked with WYDOT to craft this amendment.
Wonderful.
So,
welcome, Director Reiner. If you want to join us now, you certainly can. It's great to see you.
So Thank you, Madam Chair. So if it's all right with you, I will just run down the amendment here real quick and explain the amendment we've proposed. All right, so on page 2, line 8, it is our request that after make sure I have this right here, page 2, line 8, we would insert and those public works related to airports pursuant to Wyoming Statute 10-3-201B. And what this does is it puts the same comment that the Road and Bridge public works are under for the State Transportation Commission. So on page 8, it calls out road and bridge projects under Wyoming Statute 24-2-108A. And this would also put the requirements for airport related projects under the purview of the State Transportation Commission. On page 3, line 18, after the word for, insert any items of. After material, delete the S, so it becomes non-plural, it becomes material. And then insert or, and then after equipment, insert to be. And then after line 3, or I'm sorry, page 3, line 19, after work, insert if the procurement of that item for such public work is expected to exceed 25% of the total construction cost. So combine the amendments to line 18 and line 19. We have some concerns about the fact that this current proposed language requires a performance-based specification for every material used in a public work. So it is our desire to see amendment here where if that material, if any one material is expected to exceed 25% of the total construction cost, it would be required to have a performance-based specification. And the reason for that is, as you're probably well aware, public works include many different types of materials, whether that be pavement, curbs, gutters, sewers, buildings, electrical, plumbing, roofing, painting, nails, screws, et cetera, et cetera. I go on and on with the list. And we want to avoid a situation where we're having to write a performance-based spec for even the smallest of materials that are inconsequential to a project in terms of their necessary performance. So we have selected or added this language in our amendment to keep us from having an over excessive list of specifications is what it boils down to. And then the next amendment addresses the paragraph related to transparency. Currently as written includes language that would require us to report to the State Construction Department or the Transportation Commission when we go with other than the low bid. Largely the question here, and Director Reiner will be able to fill in the holes, is once it's reported to those two state entities, what happens with it? It doesn't really add any transparency when it's reported to those state agencies because it doesn't require anything beyond that. Very aware of the language that WAM and county commissioners and the contractors have worked on, and I believe that addresses that issue, and Director Reiner might be able to address that further. And then I'll wrap up here, bringing back to the beginning of the amendment. We have to add additional language to comply with what we added on the first change on page 2. Page 5, line 13, after commission, it would insert for road and bridge projects. And then after 24-2-108A, insert and Wyoming Statute 10-3-201B or otherwise with respect to airport projects. So once again, that just wraps it up and basically says for any pre-qualification process, airports will follow under the purview of WYDOT and not the State Construction Department. And the reason for that is WYDOT already has jurisdiction over our construction and maintenance projects under 10-3-201B. And it seems to make sense to keep airports under WYDOT and not have us also add the State Construction Department as another regulating entity or governing entity under this this requirement, if that makes sense.
Thank you, Mr. Brubaker. Any follow-up, Director Reiner?
Thank you, Madam Chairman and members of the committee. For the record, Luke Reiner, Director of WYDOT. Let me first thank Mr. Brubaker for his leadership on working this on really behalf of WYDOT. And then also acknowledge the efforts of AGC, the counties, and WAM, because I think they did some good work there. Relative to my uncomfortableness with the language on really, line 1 through 4 on page 5, I just was very uncomfortable with the appearance that commissioners and or mayors would report to WYDOT and to the commission, because I don't think that's how our government works. And I don't think I have any oversight responsibility of those entities. I'm fully vested in transparency and completely support that effort. And so it's not an effort for me to avoid transparency, but it's really roles of government. It was my concern. I would consider it basically, I think, a friendly amendment to suggest to Mr. Brubaker that we can strike our really opposition to the language if the language that WAM and AGC and the County Commission Association inserts there, because really that says, hey, make available to the public its rationale, or I would still ask the question, what do you want us to do with it? But I really do want to be on record of saying, hey, for the commissioners or mayors that might be listening, it's not our business to oversee what you do. Madam Chairman, that was my logic behind really my concern with that paragraph, and I think it's mitigated by the suggested amendment by the other group.
Thank you, Director. Committee questions for Mr. Brubaker or Director Reiner? Senator Kolb.
Thank you, Madam Chairman. Just a question, when was that sent out, the proposed amendment that you're now proposing, Mr. Brubaker?
Mr. Brubaker?
Madam Chair, I believe it was sent out last week, and I apologize if it didn't make it out to the entire committee. We can get that addressed very quickly and get that out to the whole committee. I thought it was sent out already last week, I believe.
Wow.
Mr. Brubaker, who would have sent that out?
It would have came from, Madam Chair, it would have came from Charlene Kaiser with our public advocacy firm that works with us, works with the airports.
All right, thank you, Mr. Brubaker. All right, committee, any additional questions? Any follow-up, Mr. Riemann, Ms. Legursky, Mr. McLaurin, that you'd like to comment on?
Yes, Madam Chairman, this is Katie with AGC of Wyoming, and just following up with this discussion on the transparency section, we would be perfectly acceptable to just adding the language after shall on page 5, line 2, that says make available to the public its rationale, period, and deleting the rest of the line. Excuse me, the rest of the sentence. So that it would strictly leave a public entity that accepts a bid that is not the lowest bid for a public work shall make available to the public its rationale, period.
Thank you, Ms. Legursky, very helpful. Committee members, did you get that? Nod your head if you did. I'll be asking one of you to make that motion. Seeing that you haven't, Ms. Legursky, let's do it one more time. I'll be asking one of you to make the motion, so understand what you're going to be asked to do here in a minute. So if you could pay the page number and the line number and specifically what you're asking, Ms. Legursky.
Yes, Madam Chair. On page 5, line 2, after the word shall, insert make available to the public its rationale, period, then deleting the rest of the sentence, which is provide a report in writing to the State Construction Department or to the State Transportation Commission, which is ever applicable to the public work.
Committee, did you get that? Nod your head. Okay. All right. We're going to make this easy and you're going to look smart. All right. Thank you, Ms. Legursky. Appreciate it. All right. Is there any further public comment? If so, please raise your hand. I think there's one panelist. I can see a hand raised. Mr. Madsen. Great to see you. Welcome to the committee.
Thank you, Madam Chairman. Mark Madsen, William H. Smith and Associates, formerly a contractor, formerly DOT engineer. So hopefully I've got them all covered. I just want to thank everybody for coming to this. I can't tell you how much it means to the association and the members to know exactly why a decision was made, and to really applaud this transparency, making sure public funds are used in the most transparent way so that everybody understands why. And that's, as an engineer, I don't want to speak long, right? So I'm done.
I must say right now, engineers I prefer over lawyers. Thank you, Mr. Madsen. Greatly appreciated. Questions for Mr. Madsen? All right. Any further public comment? Please raise your hand if there is. All right, again, all of those stakeholders here with us, I'm not going to let you go quite yet, even though we're going to close public comment. We're going to work the bill, but I do want you to stay close because you have provided us some very thoughtful and technical amendments. Want to make sure, again, we get these right, and so it'd be helpful if you stay close to ensure that we do that. So public comment is closed. Committee, what is your pleasure? Senator Cost is moving the bill by the raise of two fingers. Or no, I'm sorry, that was Senator Kolb and seconded by Senator Cost. So moved by Senator Kolb, seconded by Senator Cost. Discussion on the bill. Committee, I think that there are some amendments. Senator French is prepared to bring one.
Yes, Madam Chair. Is it appropriate on page 8, where it's under 24.1.132, its existing language, to add an amendment on that page?
Certainly is, depending on what you want to do, but likely it's appropriate as long as it's within the scope of the bill.
I believe it is. I would like to add on page 8, line 15, after the word bridge, and all subcontractors have been paid by the general contractor. So that sentence would read, starting back up there at line 12, no final payment upon any contract shall be made until the bridge is examined and approved by the professional engineer supervising the construction of the bridge, and all subcontractors have been paid by the general contractor, and the payment is approved by the county commissioners or governing body of the city or town or their designees. The reason I'm offering this amendment, we had an issue years ago in our county. We had a very large project, and I can't remember, it's been years ago, I can't remember exactly what it was, but the retainage, I believe it was 5% retainage that we kept until everybody, all the T's were crossed and I's dotted and everybody signed off on it. Then we would pay that contractor that retainage, and it was a substantial amount. Well, we were just days from doing that, and a subcontractor contacted me and said, I have not been paid, and you're about to close the books on this project, and I am owed $100,000. So that's why I'm bringing it. That's my rationale.
Thank you, Senator French. Is there a second on Senator French's motion? Seconded by Senator Cost. Discussion on the motion for the amendment. Senator French, I have a question. It's my understanding that when you have a general contractor, I mean, the value in that on a very superficial level is that they manage all of the subs. And so you just have, as the consumer, you just have to engage with the general contractor, and then you pay the general contractor, they pay their subs, they hire the subs. Would this interfere with that? Do you think?
I don't believe so. When we hire a contractor like that, we're quote, the owner of the project, right? And so we enter into that contract, and we enter into it with the assumption that everybody involved in that project will be paid, because that's coming out of the county coffers. We as the owners are using the public's funds to do this project. So we're under the assumption that everybody will be paid. Well, that circumstance I related to you, that sub was just about to not be paid before we closed the books on the project and paid the retainage to the contractor. So I hope that gives you some background there, Madam Chair.
Certainly. What if you don't want to pay the subcontractor? What happens? You're statutorily obligated to pay the subcontractor now, but what if they did bad work?
Well, if that sub does bad work, we have that 5% retainage, which is a significant amount depending on the size of the project. So if it's brought to our attention that the electrical sub did a poor job on your jail or your community built, whatever it is, we're going to know that. So we're going to say to the general contractor, the main contractor, that didn't meet the specs, that's subpar, and we don't feel we need to pay you your 5% retainage. So I think there's short of that, everybody's going to end up in court over it.
And we know that there are lawyers to do that. We've heard from them.
Yes, I've heard that.
All right, thank you, Senator French. Senator Kolb.
Thank you, Madam Chairman. To my good co-senator from the ex-commission world, you know, we've been involved in many issues, you know, here in Southwest Wyoming, and with that, it really becomes down to the fact that we hired a contractor to do a job, and if there's an issue with said contractor doing that job, that we have an issue with them directly. The subs, you know, of course, get paid by the general contractor, but we had quite a few issues in building the last project that I was involved with, and it had to be settled in that manner. We couldn't intervene. We couldn't put ourselves in there to substitute for the contractor. You know, frankly, we hired him, and it was up to us to work with him, and it was his job to deal with his subs. And that's the legal understanding that I have of how this would transpire or how it would happen. It's unfortunate when you find out things like this, when you try to do the right thing. We had an issue here in Sweetwater where they didn't pay a sub for gravel and they owed them $50,000. Well, that's true. They made right by it, you know, so the issue was settled. But we were told, at least by our counsel, that we were not supposed to be injecting ourselves at that level of the project. So that's why I'd be hesitant to, you know, move forward with such a, you know, with this type of an amendment. I think there's a system out there, and we have to use that system. And if we don't, we're going to find ourselves in a more liable situation, at least as a county would, let's say in that case. Thank you, Madam Chair.
Thank you, Senator Kolb. Senator Cost.
Thank you, Madam Chair. I guess I'm paralleling with the good senator from the Rock Springs, Green River area. When a general contractor is hired, I think the general contractor is in charge of the subcontractors and should take care of that. And it's kind of like getting into the weeds when the owner is trying to step down to run things differently. I think making the contractor aware of problems or things that aren't done and having them take care of it is necessary. But to put it in here this way, it's almost like you don't need the general contractor because you are the general contractor. So for those reasons, I think I'll be hesitant to vote affirmative.
All right, any further discussion on Senator French's motion? Senator Cooper.
From the private sector side, I can say that in the instance where the sub doesn't get paid, the owner of the project ends up being liable for those bills to the sub, and the sub can file a lien on the project, if you will. So I think it's very important that we protect our subs and make sure they are paid before we close a project out. Thank you.
Senator Cooper, thank you. Very good thoughts. I think our contracting requirements require that we get lien waivers from those subs. At least those good public attorneys do. Well, just hold that thought. Ms. Creech, I see you're present here, which usually means you have something very important to share with us. So if you would let us know.
Madam Chairman, thank you. I just wanted to make sure that the bill was moved prior to voting on the amendment itself.
Right. I think you're correct, Ms. Creech. I appreciate that. Did we get a motion on the bill? I think we did, right? Yeah, I think it was moved by Senator Cope, who did one of these, and then Senator Cost, who seconded that. Thank you, Ms. Creech, though. It is a little out of order, and that's why we shouldn't do that. So I appreciate that good reminder. So right now, committee, we are on Senator French's motion to amend the bill on page 8, discussing the payment of subcontractors. Representative Stith is raising his hand, and although he's not a member of the committee, I do appreciate his expertise, particularly on this bill. So again, we'll break with the rules here and hear from Representative Stith.
Madam Chairman, again, sorry to interrupt. And I have great sympathy for Senator French's position, which is a position that I argued on the House floor last year in connection with what was then called House Bill 52, that became an enrolled act. And the compromise that was struck essentially in the 2020 session was that the owner would make the final payment without regard, frankly, to whether the general contractor had paid all the subs or whether the owner had verified that. But the subcontractors were given extra time to file against the surety bond. And so the idea being that if the owner is happy with the quality of the project, and if the owner is paying only the contract price, and if the subs who are unpaid have adequate remedies from the surety bond company and the general contractor, they can hash that out in court amongst themselves. And so that became an amendment to Wyoming Statute 16-6-117. And again, there was a lot of debate about that. And Senator French, I'm sympathetic to your position, frankly, but just the history of it is that's sort of how it got resolved for public works contracts generally. And I don't know if Ms. Ligursky has a different recollection of that or not.
Thank you, Representative Stith. Very helpful. Ms. Ligursky, would you like to comment?
Thank you, Madam Chairman. My recollection is the same as Representative Stith. As you guys all know, last year we had 3 construction bills that we debated at length through the Joint Appropriations Committees, and one of them was on final payment to the contractors and the subcontractors.
Thank you, Ms. Ligursky. And are those subcontractors protected?
Yes, Madam Chairman, they are. Representative Stith did clarify that, and some of the work that was done to House Bill 52 basically says claims on a contractor's bond will be allowed for 1 year from the date of final payment. It also specifies that claims from a subcontractor against a general contractor shall be against the surety bond and should not prevent final settlement payments to the general contractor.
Once again, remarkable, Ms. Ligursky, appreciate you. What a good decision I made to go out of the rules. Thank you both. Okay, committee, we're back on Senator French's motion to amend the bill. Further discussion? All right, seeing none, I'm going to call question on the motion. All those in favor of Senator French's motion to amend Senate File 6 on page 8, as indicated, please raise your hand. All right, we have 1. All those opposed, please raise your hand. Senator Cooper, you have to vote. All right. That is one to four. Senator French, it was a good discussion, and I think we learned a great deal on this, and we'll be prepared for that on the floor as well. So thank you for that motion. That motion has failed. So back on the bill committee, further amendments committee. So the amendment that was emailed to us from Ms. Legursky, that was agreed upon by all the stakeholders, that needs to be moved by us and amended into the bill. Senator Cost, are you prepared to make that motion?
I believe I am. I was going to ask a question first. Where they've the previous removal of reasonable and that is still in, and has that amendment been taken care of, or is that needed at this time as well?
I think that issue is still up for us to decide whether or not for the word reasonable.
Okay.
But that amendment is included in the, I would say, compromised amendment by the stakeholders. And so if you don't want to move that, that's a question for the committee to decide. But if you want to move their amendment in total, that would include the striking of the word reasonable.
Okay. So if I'm understanding correctly, the amendment I would suggest is on page 5, line 2, after shall make available to the public a report in writing.
Let's all take a minute and get that one up. And so this will be an email forwarded from me with Ms. Legursky. Let me just email it again to bring it top to your inboxes. And Senator Costa, you're doing the right one, but I'll just do it again.
Okay, I might not have the words correct, but I think I'm close.
You are. You're correct. Make sure we're all following. Okay, so please proceed, Senator Cost.
Okay, it's on page 5, line 2, after the word shall, strike provide and insert make available to the public a report in writing, and then strike the rest of the line and 3 and 4 is the way I understood that to be.
That amendment, yes, that's the one that you're bringing. Wonderful. Great. So all those in favor of Senator Cost's amendment, is there a second on Senator Cost's motion?
Second.
Seconded by Senator Kolb. All those in favor, please raise your hand. All right, that motion passes unanimously. Committee members, I just sent you the pretty robust email amendment, which is actually the compromise amendment. Take a minute and look in your inboxes. It should be the very top.
Madam Chairman,
Yes.
I'm sorry, but I am very confused. On the amendment that you just approved, is that the one that you just sent out by email that says a proposed amendment that starts with page 2, line 8?
No, it is not. Okay. So Senator Cost, let's go through this again and just explain the amendment so we have it for session staff.
Thank you, Madam Chair. Are we all ready to go?
Yes, so Senator Cost, committee members, what we're doing right now, we just passed the amendment that Ms. Legursky offered us to do to deal with the issue of transparency. And everyone seemed to feel like that was the right result, including YDOT and the airport, and everyone is in agreement with this. And this was the one that I said, listen carefully on page 5, line 2. So this is just that very short amendment where we delete most of the language. So go ahead and just repeat what we just passed for the purposes of the record.
Thank you, Madam Chairman. On page 5, line 2, after the word shall, strike provide and add in make available to the public. Then next will be what's already in there, a report in writing. Put a period there and strike the rest of line 2, all of line 3, and all of line 4.
I do think that's correct. Ms. Legursky, is that correct?
Madam Chairman, what my recommendation was is on page 5, line 2, after the word shall, insert make available to the public its rationale, period, then delete provide a report in writing to the State Construction Department or to the State Transportation Commission, which is whatever is applicable to the public work. So in other words, that section would read, a public entity that accepts a bid that is not the lowest bid for a public work shall make available to the public its rationale.
Ms. Legursky, can you email that to us?
I'd be happy to.
Thank you. Committee, you just heard that. Is that the motion that you, is that what you, Senator Kolb, you raising your hand?
Yes. So on my copy that I just got, it has after rationale or provide for a report in writing to the State Construction Department. To continue that line on page 5, starting at line 2. It's correct, except it's not a period after rationale. It says or on mine, and then it goes on to say provide a report in writing to the state, so on. Do I have the wrong one, or?
I'm not sure which one you have.
Well, the one you just sent me. It's handwritten in mine. It's written in green.
Great. Let me just pull up all my, people are emailing me simultaneously as well. So, let me pull this up here.
Madam Chair, Katie Legursky also had her hand raised momentarily.
Wonderful. I'm just going to take a moment and read what's in front of me to help get us all straightened out so that I can help rather than just call on musical chairs. Ms. Legursky, go ahead and make your camera available for us and bring us back. Ms. Legursky, we have the robust amendment that you provided, which had a series of amendments in it, and then also it addresses page 5 as well. Is that a second amendment that you wanted to seek to address the transparency piece or not?
Thank you, Madam Chairman, and I cannot add my camera since LSO hasn't given me permission, but luckily you guys can hear me. After discussion from the airport operators as well as the director of YDOT with their concerns of having a report filed directly to the State Construction Department or to the Department of Transportation, it was my recommendation at that point just to strike the language that says provide a report in writing to both of those entities and just stick with the language that says make available to the public its rationale. So that is an amendment to our amendment.
That's the question. Thank you, Ms. Legursky. So,
thank you.
Yes. Which is why I wanted to maybe move this amendment first. Okay, so what we're doing is we'll get that amendment from Ms. Legursky. Judy, just hold tight and I'll get you that language for the record to make sure we move the proper amendment. So Judy, I'll follow up with you with an email with the accurate language.
Thank you.
Committee. I'm going to move this. Committee, you have in your inbox an email from Ms. Legursky that is the one that Senator Kolb just referenced that has the green language on it, the green handwriting on the bill to help you understand it. Also written within that email is the actual amendment language itself. And so you can see that on page 3, line 17. We're going to delete the word reasonable. And this is an issue that's up for debate that Representative Stith mentioned. I'm going to propose to you based on our previous testimony that we received and what this committee was in agreement before that we strike that word reasonable. If you want to come back and talk about that later, we'll do that, but not right now. All right, so this is that page 3, line 17, we're deleting the word reasonable. On page 5, line 2, after the word shall, we're inserting make available to the public its rationale or, and this is where that confusion comes in because this amendment was proposed to us first and there's an amendment to this particular amendment. So we're going to pass that, and then I'm going to fix that. So page 5, line 2, after shall, insert make available to the public its rationale or. Then on page 5, line 7, after the word of, insert the counties, cities, and towns. On page 5, line 12, after the word by, insert the counties, cities, and towns pursuant to Wyoming Statute 24-1-132H. On page 9, line 1, insert H, adopt uniform rules for the pre-qualification of bidders on contracts for public works as provided in Wyoming Statute 16-6-119B. And finally, on page 11, line 13, after the, insert counties, cities, and towns, the. Committee, do you all have that amendment that you've just read we walked through? Yes? Yes. Great. That is my motion. Can I get a second to my motion on that amendment? Seconded by Senator Kolb. Discussion on that amendment. Good senators, this is the one that has been fully supported by all the stakeholders. There's no disagreement. Is there any discussion? Okay, no. All those in favor, please raise your hand. That's a unanimous vote, and that motion has passed. All right, good senators. What I'm going to do now is clarify what we did, okay? So we're going to do the second amendment on that first amendment on page 5, line 2. So we're going to go back and fixate there for a second. And this one is on page 5. I'm going to move that on page 5, line 2, after the word shall, we insert make available to the public its rationale, then delete the rest of the sentence. Is there a second? All right, seconded by Senator French. All those in favor, please raise your hand. That motion has passed. All right, good senators, I have a third motion. This motion will have come from the airport folks. And so, good senators, I move that on page 2, line 8, after Romanet A, we insert, and those public works related to airports pursuant to Wyoming Statute 103201, Romanet B. On page 3, line 18, after 4, we insert any items of, after material, delete S and insert or, and after equipment, insert 2B. And Judy, I have this to provide for you so you don't have to worry about tracking it, but for purposes of transparency, I'll read it in. On page 3, line 19, after work, insert if the procurement of that item for such public work is expected to exceed 25% of the total construction cost. And page 4, line 23, after the quotation or after the period, delete a public. On page 5, line 13, after commission, insert for road and bridge projects. After Wyoming Statute 24-108A, insert and Wyoming Statute 103201B, or otherwise with respect to airport projects. So hold on just a minute, and I'm going to double check something with my other notes. And so I have not adopted one portion of that amendment where we're not going to delete lines 1 through 4 entirely. And we're not doing that because we heard testimony that the airports And AGC, everyone agrees for that compromise language from the amendment we just passed. So I have modified that proposed amendment from the airport slightly by not adopting their recommendation for page 5 and deleting lines 1 through 4. We've kept that in. So it's just for clarity, but we've adopted the majority of their requested amendments. With that, I'd ask for a second. Seconded by Senator Cost. Discussion on the amendment. Senator Kolb.
Yeah, thank you, Madam Chair. If I can keep up with this, I had a question, I believe on page 3, line 19, when you inserted the percentage of project quote amount to be 24%. And I'm wondering, why is it 24% and what is the background with that number? If you understand where I'm at here in all those language amendments.
Yes, Senator Kolb, great question. So it's after work insert if the procurement of that item for such is expected to exceed 25% of the total construction costs. And so in order to make sure you have your questions fully answered here, we'll go back to Mr. Brubaker. Mr. Brubaker, if you can come back online.
All right, Madam Chair, can't turn my video on, so I'll spare you that, but I think you can hear me, Madam Chair.
Please proceed.
All right, so Madam Chair, Senator Kolb, appreciate the question. We expected this question to come up, and quite honestly, this was just a number we picked. We are open to other discussion and other numbers here. We just know that we were just trying to find a starting point for the discussion with this percentage. So we are open to other ideas and other amendments to that.
Mr. Brubaker, did you share this proposed amendment with Ms. Legursky?
This has been shared, Madam Chair, with the contractors through, once again, Charlene Kaiser.
Is there any comment, Ms. Legursky, from you on this particular question?
Madam Chairman, no, we are fine with the amendment that the airports did propose here on this. I believe that the reason that this section is in this bill is that a former member of the Joint Judiciary Committee had some concerns with some radio operators not being able to compete because entities were writing the specifications so prescriptive that they were looking at only allowing a certain manufacturer to bid on some procurement projects. So that's why this was included in there, but we are perfectly fine with the amendment that the airports had suggested.
Thank you, Ms. Legursky. Senator Kolb, do you have further questions?
Yeah, it doesn't really clarify it. I think we're talking about maybe an M here, but I wouldn't say it on certain suppliers of parts and pieces. I still don't understand why it's 25. I mean, can someone understand? I mean, I hear it was just kind of an arbitrary thing you brought up, but why should it be more? Should it be less? I mean, I haven't heard anything factual about why the number is what it is besides, I guess, what Mr. Legursky just explained. Could anyone help me out with that? Thank you, Madam Chair.
Mr. Brubaker?
Madam Chair, Senator Kolb, once again, this was just a starting point for a number. We don't have a specific data point to reference back to this. We just wanted to make sure that we were not writing performance-based specs for the smallest components of a public work project. And Madam Chair, if I might, while I have the screen and be able to talk to you, in the amendment you read in, page 4, line 23, the word delete a public, that should remain based on the agreement that this committee just approved for the transparency paragraph. That would be deleted from our amendment.
That is correct. That's what I did read in. So the only piece of your amendment that I did not propose was that second one from the bottom where it says page 5, line 1 through 4, delete entirely.
Well, Madam Chair, I apologize. I'm probably not using the correct words. That page 4, line 23, that should remain as well. In terms, it should remain in the bill, not delete out of the bill. So in our amendment, that line should be deleted to maintain that paragraph or that sentence that that you all amended earlier.
Oh, sure. Okay, great. Thank you. Committee, I'm going to ask you to kill this amendment. And we'll try to work it on the floor if we can as a result of when we received it and what we've done. So Senator Kolb still has questions about the 25%. I think the bill is difficult. I want to make sure we track it in to the airports. We'll bring it out as a separate standing committee or as a separate amendment for first reading for committee on the whole as a separate amendment. I promise to do that for you, but I'm not going to continue to jack with this bill right now because the committee doesn't understand what they're actually voting on or what they're amending. Director Reiner.
Madam Chair, I appreciate what you're saying there. I might recommend to you, ma'am, that the very first line of the proposed amendment be adopted, which is on page 2, line 8, that adds, and those public works related to airports pursuant to, and that paragraph.
Roger.
And then I can concur with your decision on the rest. Thank you, Madam Chair.
Thank you, Director Reiner. Committee, I'm going to ask you to vote no. All those in favor of my motion to adopt this particular amendment, please raise your hand. Seeing none, that amendment has failed. Committee, I have a motion on page 2, line 8. And Judy, if you could get this, please. Page 2, line 8. After subparagraph A, insert and those public works related to airports pursuant to Wyoming statute 10-3-201B.
Could you repeat it one more time?
Absolutely. Page 2, line 8. After A, insert and those public works related to airports pursuant to Wyoming statute 10-3-201B. And I can do it one more time if you'd like.
One more time would be good.
Great. After A, insert and those public works related to airports pursuant to WS Wyoming statute 10-3-201B.
Thank you very much.
Absolutely. Is there a second? Seconded by Cost. All those in favor, please raise your hand. That motion has passed unanimously. Okay, with that, committee, is there any further discussion on this bill? Senator Cost.
Thank you, Madam Chairwoman. I have one question now. That I'm under the assumption that took care of Director Reiner's concern. That motion, that amendment did. Is that
Director
correct?
Reiner?
I
You're muted,
believe-
Director Reiner.
Madam Chairman, Senator Cost, yes, thank you.
Okay,
Thank you, Director.
no further questions.
All right, committee, further discussion on the bill? Do you know what we just did? We'll track it in. I'll carry this bill on the floor, good senators, and I will also move all the amendments in. So not to worry about that. Seeing that there's no further discussion on the bill, roll call vote on the bill.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
and Chairman Nethercott.
Aye.
Thank you.
Good senators, I would direct all your questions to Representative Stith.
Thank you, Madam Chair.
Absolutely. Ms. Legursky, Mr. Riemann, Mr. McLaurin, Mr. Brubaker, Director Reiner, Mr. Madsen, I want to appreciate all of you for walking through that very difficult bill with us. I know that was pretty painful. Ms. Legursky, special credit to you for being so sharp. So thank you so much for being here. Okay, with that committee, we're going to take a short break until 4 o'clock. We only have until 5:30, and that's a hard stop then. So I just want to let you know that we'll only have an hour and a half left. So I anticipate that we'll probably only be able to get through Senate File 87, the Voyeurism Amendments Bill. Of course, you never know how testimony goes, but that's okay. So Senator Cost and those watching who are interested in the hemp bill, we probably won't be able to get to that tonight. So we're probably just going to get through Senate File 87, at which point we will start right on the dot at 4 o'clock. So we'll see you in 7 minutes. All right, committee, it looks like we're all back. I hope you had a great break. We are here. We have a quorum, 403, ready to really switch gears again and pivot from public works contracting to voyeurism. So pretty fast here. So with that, we are back streaming live on YouTube, and we have Senate File 87, Voyeurism Amendments, and we have the good co-Senate Judiciary Senator Cost, here to present this good little bill for us. So Senator Cost, please proceed.
Thank you, Madam Chairwoman. If I can talk now, and committee, I bring to you today Senate File 87, Voyeurism Amendments. This is an act relating to crime and offenses, amending the elements and penalties of the crime of voyeurism, authorizing the imposition of specified probation conditions for those persons convicted of voyeurism, making conforming amendments, and providing for an effective date. What this really does is it tries to re-identify a few things that were left out and set penalties for what would be classified as voyeurism. In section 1, you will notice that there will be an addition to the intro and 3, and then creating new paragraphs 5, Romanet 5 and Romanet 6. B intro will be also added to, and Romanet 2 will be added to, and by adding new subsections. So I'll walk you through that fairly quickly. On page 2, line 1, added into A is, except as otherwise provided in this section, a person. And as we go on down, you'll see in 8, enclosed has been removed. And then it's limited to, and these are identifications. 1, Romanet 1 is not in there. It's in the normal bill, and it says restrooms. Romanet 2 says baths. Romanet 3, we are removing the or. Romanet 4 is in the original bill, which is dressing rooms and fitting rooms. Romanet 5 is being added bedrooms, and then a semicolon, and then or. I'm sorry, that's on line 14. I should be stating that, and I apologize. On line 16, Romanet 6 states, under the clothing being worn by another person, regardless of whether the person is in a place where the person has a reasonable expectation of privacy. On B, Romanet B, except as otherwise provided in this section, a person is guilty. And then we go on down to page 3, line 3, we add a colon. Line 5, we add a, and the 4, it shows the red on the 4 instead of or, the purpose of let's see if I can say that, of observing, viewing, photographing, filming, recording is added in, or videotaping the intimate areas of another person. And then there's a semicolon at the end of line 7. Line 9 adds B, and the U of under, the is struck, clothing being worn by another person. And then there's a semicolon, and it says and. On line 10. On line 12, C strikes where that other person has not consented to observing, viewing, photographing, filming, or videotaping. And on line 14, added in without the consent of the other person. On line 16C, is added, a person who commits an offense as specified in this section for which the victim is less than 18 years of age shall be guilty. I apologize there. I just tried to make that 190 large. Shall be guilty of a felony punishable by imprisonment of not less than 2 years, a fine of not greater than $5,000 or both. D is added on line 22 on page 3, and it says a person who commits an offense is specified in this section who has previously been convicted of and then on page 4, line 1, offense under this section or under a similar offense under the laws of another state shall be guilty of a felony punishable by imprisonment of not greater than 5 years, a fine of not greater than $5,000 or both. Line 7, E, in addition to the penalties specified in this section, a person guilty of the offense of voyeurism shall serve a term of supervised probation of, we go down to 11, Romanet I, 1 year for a violation of a paragraph B, Romanet 2I or 2 of this section. Line 14, Romanet 2, not less than 1 year and not greater than 2 years for a violation of paragraph Romanet B, Romanet 2 of this section, where one or more photos, video segments, or clips, or other images or media of the victim are disseminated to another person or posted on the internet. Or Romanet 3, not less than 3 years for any violation of this section where the victim is less than 18 years of age at the time of the offense, notwithstanding Wyoming statute 713-302B. And that's on page 5. And then on page 5, line 4 is F. As used in this section, intimate area means any portion of a person's pubic area, buttocks, vulva, genitals, female breasts, or undergarments intended to cover those portions. Intimate area does not include intimate areas visible through a person's clothing or intimate areas knowingly exposed in public. We go on down to 713-304, imposition or modification of conditions, performances of work by the defendant. Line 14E, as a condition of probation or suspension of sentence for a person convicted of an offense under Wyoming statute 64304, the court may require the defendant to complete successfully a sex offender treatment program. And section 2 is an effective date of July 1, 2021. So that's the original bill in its entirety, and I would entertain any questions at this time.
Thank you, Senator Kolb. Questions for Senator Cost. Sorry, I'm looking at Senator Kolb. Questions for Senator.
I believe it's called removal of a dog.
Thank you. Sorry about that. Senator Cost, great job. I have a couple questions for you, Senator Cost. On page 5, lines 14 through 17, this particular provision, do you think that this is a requirement that should be in the bill, or is this something that the court can do already?
That was a discussion that I had with the LSO, and to be honest with you, obviously they could do it, but this prompts them to think of it as a provision rather than, it's not in requiring it. It's saying this could be, so it's just a general reminder that this might be a way to avoid something. In some of the work that we found and the data that is out there, voyeurism has a tendency to lead to other things. And if this could stave off some of that, then it was recommended as probably a decent recommendation. At the same time, I was told you don't tell judges what to do, so you don't put it in as an order.
All right, great. Thank you, Senator Cost. All right, no other questions for Senator Cost. Senator Kolb.
You're on mute, I believe.
My even computer told me I was on mute. On the page 2, line 6, inserting knowingly in front of that. Just, I don't know if it's the time to comment about that. We didn't move the bill yet, so maybe it's too early.
Senator Kolb, hold that thought for potential amendments. We'll hear public comment first on the bill, and then we'll move the bill and then do amendments on the bill. But I think that your comment is appropriate at this time for those listening and who might provide public comment to consider that as well. So Senator Kolb, if you would just repeat that and your concern again and maybe explain that, so some of those folks who wish to provide public comment can maybe speak to that issue.
Certainly, Madam Chair. Page 2, line 6, it just inserts the word knowingly after the first, before this was viewed, comma, then insert knowingly. And I guess I would like to hear if there's a factual reason why it would diminish what this bill can do. I just wanted to put a provision in there to make sure that, frankly, we don't have an innocent person charged with this. And I think if it has no harm to it, I'd like to, hear the opinion of people that may testify about, what they think of that idea. Thank you, Madam Chair. Did I explain myself well?
I think that's perfect, Senator Kolb. Thank you so much. So those in the waiting room, I see some of the attorneys we heard before, and I hope they stick around, and I'm glad to see them here. Mr. Barone, are you available? I'm going to bring you into the room. I hope I did. Wonderful. So glad that you're here, Mr. Barone. Do you have some comments on this bill?
Okay. Thank you, Chairman Nethercott. My name is Joe Barron, like Red Baron Pizza. And a lot of people say Barone. That's how they pronounce it east of the Mississippi River, where my dad's family is from. Over here, we're Barons. Over there, we're Barones. So
it goes with Joe, Mr. Barron.
So thank you. Yes, I'm here on behalf of the Prosecutors Association, and we generally are in favor of this particular bill, and it covers a couple problems that may exist. One of the things before I go to the exception, I just want to make sure that it would be on page 2 that we get our punctuation correct on this, and after little Romanet 4 that's set forth in the existing statute, we get rid of the period and put a semicolon there, and so we don't have a period in the middle of the string there. It's just something I'm starting to look at, and so it's that's one thing that's there. The other thing, the question was asked on page 2, line 6, about inserting knowingly there within that. This is the way I look at this here from a kind of a practical point of view, but to compare it to, there's not a crime of when you get a ticket for speeding, there's not a requirement that you knew that you were speeding. It's a question, were you speeding, yes or no? And there's not a knowingly requirement within that. It's just you do the act, and it's prosecutable for doing the act. If you insert knowingly on that, it requires an additional bit of proof that the person knowingly did it. That's going to be in a jury instruction there. So obviously, that is going to make it a bit tougher to prove in those cases. Now, obviously, people can make inferences that the person knowingly did this, but by inserting the word knowingly in there, it does make it a bit harder to prosecute, because that's just one more thing that the state would have to prove within that. In looking at the rest of the statute, it just seems like it would be pretty hard to do all this stuff and not know what you were doing. You know, from what I see there in the statute, but simply put, that's what knowingly does. It just makes it a little bit tougher to prove.
Thank you, Mr. Barron. Mr. Barron, I have another question for you as it relates to the reference, trying to find it, where taking a picture of a minor, so under the age of 18. Let me find the section number. I'm curious to hear your thoughts about that. That's on page 3, line 16 through 20.
3, line 6. So, Chairman Nethercutt, are you looking at my comment as it relates to other laws that might pertain to some kind of facts like this? I'm pretty sure there's the what this thing does isn't, I think there's a minor one, and I'm sorry that I'm not up on this as well as I should be, but there's another law as it relates to minors, voyeurism on other minors type of thing. And what this does, obviously, it says a person, so that's anybody that doesn't distinguish based on age. So you could quite possibly bring that cause of action against a minor here. Of course, they would be subject to, going through diversion or going to juvenile court or anything like that. But it could affect minors. I mean, a minor. I could charge a minor under, if they were, 16,
there are
17.
two concerns that I had with that, and just want to make sure that it doesn't affect or interfere with our child pornography statutes, which of course this would potentially touch on. And so want to make sure there's no interference with that crime. And then I am aware too, and have not used it, that I think in about 2017, we passed legislation to provide different remedies for juveniles who are taking photos, as opposed to charging them with more serious crimes as a result of that becoming, unfortunately, common practice. So those two pieces certainly, but primarily concerned about any interference with a serious charge associated with child pornography and there being any kind of conflict of law situation occurring with that. So we just draw that issue to your attention. I haven't seen that myself, and I looked at that statute, and I do think that this bill fills a gap where potentially that image is not being produced for production or for those other purposes. But I just want to make sure that we really think that through. And it also covers not the recording, but a peeping Tom into a child's room, right? I just want to make sure we don't do any harm on those really important crimes so that we're able to successfully prosecute those types of crimes because they're so important to successfully convict.
Chairman Nethercott, just looking at that statute 64303, it, you know, when they define that, they define child pornography, and there's usually visual depictions involving the use of a child engaged in explicit sexual conduct. It, just looking at this, it appears that the child pornography statute, sexual exploitation of children, 64303, deals more with the sexual acts involving children and visual depictions of sexual acts involving children. And that's, I'm not seeing anything that I don't even think that this voyeurism law, it frankly doesn't even appear to me to be even like a lesser included of the sexual exploitation statute.
Mr. Barron, I agree with my initial assessment of that, but I do want you to keep studying it if you would, just to make sure. Or that there isn't any gap in the law that we can further address with this bill related to that type of conduct. So.
Yeah, there's somebody that was working on that, and I'll send that to them. I have to figure out who it was now.
Committee, any additional questions for Mr. Barron? Senator French?
Well, to Mr. Barron or you, Madam Chair, on that very same thing, page 3, 16 through 20, what if the person that commits the offense is a minor, also is under 18? What are they, can they be charged with the 2 years felony, or does it go into a different type of court where they're not, quote, an adult?
Mr. Barron, if you can, and I can help and then pivot to him. So in light of that increasing concern and behavior of youth with access to phones that have cameras, we did in about 2017 pass legislation in order to make sure that youth who are committing that type of conduct are not being pulled into becoming felons. And so there's special juvenile statutes addressing that particular conduct and bringing them into juvenile court, and different diversion type programs, and identifying the defendant that's a juvenile. Of course, there is an opportunity for a prosecutor to use discretion. For example, if the offender is 17 and the minor is 8, right? That might be very different as opposed to what we're thinking of 2 15-year-olds. But so it's important for the prosecutor have discretion to evaluate the difference between what a minor means in those potential scenarios, 17 versus 8 or 2 15-year-olds. Very different conduct. Any follow-up, Mr. Barron?
Yeah, I would agree with that. I mean, the cases that we see, frankly, the ones that we see on this kind of thing, they seem to run in streams, and you'll get a bunch of them at one time, and it's kind of all connected. And we've been able to use the voyeurism statute. Actually, this dissemination under 64305, we've actually been able, most of that through a diversion program that we have in the office. So we're able to do it before they get to court. But if it's anything a little bit more strenuous than that, we've actually brought the things into juvenile court. We've had to actually file some that were more explicit under that 64303 with minors in juvenile court. I do notice one thing in the minor dissemination or possession of nude images by a minor under 305. They have a statute in there under, it indicates that, you know, the term nude images, the term does not include a depiction of explicit sexual conduct as defined in 64303 III. So even under the minor exception, you know, the minor law for voyeurism under 64305, and that's in subpart A under nude images, they actually put an exception. So in that law, so that more the sexually explicit images gets prosecuted under the 64303, which is that sexual exploitation of children with that depicts the sexual acts of minors. So they do relate to each other, and it does look like this expansion on the voyeurism law probably could use some clarification in there, but I do agree with the chairman there. It is much different for a couple of 13 and 14-year-olds than it is for, you know, when you get, you know, a 17, 16, 17-year-old kid, and you get somebody that's, you know, 8 and 9 years old and things like that, on what you can put, what you can end up doing with those things.
Mr.
So
Barron.
So I'd be in favor of leaving that in there if you on page 3, 16 through 20.
Thank you. Senator Kolb?
Yeah, thank you, Chairman. Are there remedies out there for a situation where the juvenile was taking pictures? I mean, the other choice here with what we just talked about on page 3, line 16, possibly inserting an adult there, as long as we had other penalties in place for juveniles, and it's not causing some confusion. I think that's kind of what I'm hearing at one point here. And I just want clarification from maybe the experts on the attorney side of things on their point of view about the penalties, or if we should exclude or make this reserved for adults taking pictures of minors, and what were the thoughts? Thank you, Madam Chair.
Mr. Barron?
He's muted.
Okay. It appears to me that parts of the things covered by the voyeurism statute are also covered under 64305. Specifically, you have different definitions, okay? And so under here, you have a definition under 64305, a nude image, and then turn to your definition of intimate areas, okay? And this is also, this intimate area definition adds a little bit to even the intimate area in the sexual assault statutes. But what it says in this statute is that the nude image means a photograph or video depicting a person's genitalia, perineum, anus, or pubic area, or the breast of a female. And the term does not include the depiction of explicit sexual conduct as defined by the other statute. And so your definition here adds, buttocks, vulva, undergarments intended to cover that. So there is a little bit difference. And I guess to answer your first question is that, yes, there is a statute that covers some of this in there. And so realistically, if I look at this here, it's this a person who commits this against a minor under this statute here. I have two options. If I don't have a nude picture of their butt, I can't prosecute it under the minor statute, but I can prosecute it under the new voyeurism statute with a greater penalty, which I mean, it's a lot easier to see somebody's butt. I mean, if they show it, I mean, that's just out there in today's world, more so than somebody's intimate parts. And so I think that there's some overlap here that may not make one may be more egregious than the other.
Follow up, Senator Kolb? Muted.
Hang on. Just in so much as the adult to minor and the infraction of what's proposed here. If it's it's obviously appropriate for an adult to be charged, I think, with a higher crime than it would be in some cases for a minor. So my question was really is, I'm pretty clear about the adult issue. I'm talking about a minor issue because we know minors do some pretty stupid things when they're young, and the consequences for that. And if we already had laws in place currently to appropriately deal with a minor taking pictures of another minor.
Mr. Barron?
We do have the voyeurism statute, Senator Nethercott, Senator Kolb. We do have the minor nude image statute under 64305. It asks you to look at that covers a lot of this, but it doesn't cover all of this.
Right.
And in fact, the voyeurism statute is broader than the nude image statute for minors. And so if you want to, leave that out for adults, I mean, for minors, obviously under line 16, you would just, what you could say in there is just except as set forth in 6-4-305, a person who commits an offense is specified in this section upon a victim less than 18 years of age shall be guilty of a felony. Trying to think of what else would be in there.
Senator Kolb, that would be the proposed amendment provided by Mr. Barron if you're interested in that. So if you wanted him to repeat that idea.
I would like that repeated, Madam Chair. Yes.
And then take some notes.
I am trying diligently.
All right. Just help me out. We got to take action on it. All right. Mr. Barron, if you'd like to repeat your idea.
Under page 3, line 16, paragraph C, just insert right after the C, as except as set forth in Wyoming statute 6-4-305.
Got it, I think. 64305.
I have it too.
Mr. Barron, thank you so much. Very helpful. as we continue to move this bill through, just kind of want to be mindful of all of those pieces and recognize for the adult taking the adult peeping Tom looking into the window of a child or taking a photo of a child, that's not necessarily rises to the level of child pornography, but making sure we don't miss that conduct as well. And so we'll just kind of think of all of these options, all of these terrible scenarios and work through them. Mr. Barron, I'm going to have you stand by if you can. I really do appreciate your time. Can you stand by today, this afternoon?
Yes.
Thank you.
Yes.
Any final questions, recognizing we're going to keep them around? All right, senators, with that, we'll move on to some additional public comment. Looks like we have Tara Muir. Ms. Muir, welcome. Good to see you soon. Ms. Muir, I think this will be your first time testifying in front of the new Senate Judiciary Committee. So remember to introduce yourself for the committee, and it's great to see you back.
Thank you, Madam Chairwoman. Good afternoon, and senators on the committee. This is my first time, so thank you. I'm not that nervous. It's been all afternoon. I've been watching. My name is Tara Muir. I am the Public Policy Director for the Wyoming Coalition Against Domestic Violence and Sexual Assault. I haven't met some of you, but while I don't practice in the courtroom, I do have my law degree. For the new senators, just a little definition of who we are quickly. We are a nonprofit advocacy and education member organization. We're not a government agency. There's a similar coalition like us in every state and in many tribal nations as well. Our coalition's role here is to support survivors if they are here to testify, and we've worked with them. Our largest role, though, is to represent survivors' interests across the state, because not all victims or survivors are the same. There's a lot of myths and stereotypes out there. We want to make sure public policy is broad enough to help all victims and survivors, and mostly to do no further harm with any unintended consequences, because victims have been through enough. We also represent our member programs. Chiefly, there is one in each county and the Wind River Reservation. These programs are also nonprofits funded primarily through the AG's Division of Victim Services Office through both state and federal funds. We aren't their funders, but they come to us for support, education, advocacy. The staff at your local county program could answer questions just as easily as I can. So if you need help finding them, just let me know. I'll connect you. We're here in support of this bill, Senate File 87. We appreciate the clarity it has this year, even though we've had some discussion already, versus last year's version. We want to thank Senator Koss very much for bringing it and improving it substantially. We support Attorney Barron's suggestions to align the definitions. That's always a problem. And we just want to kind of help inform the committee. Sexual assault and domestic violence, they exist on a continuum of all kinds of behaviors. Some that seem very innocent, bad boy stuff, especially with young boys, on one end of that continuum, all the way to murder on the other. But for this crime of voyeurism, the violation of privacy and fear for victims here can be just as traumatic and just as damaging as a violent assault, especially when the behavior so plainly objectifies a person's intimate area as this bill defines. Think of, instead of those innocent boys out there all the time in front of our minds when we talk about these crimes and what kind of punishment should we have, just think if this had happened to your daughter or a wife. We do appreciate 3 pieces of this bill this year: the penalty enhancement when the victim is under 18. We appreciate the option of supervised probation, and we appreciate the option of sex offender treatment that Co-Chairwoman Nethercott brought up earlier. Our coalition is very concerned about the societal problems that are associated with mass incarceration. We've appreciated the work this body has done on criminal justice reform in the past and continues to do. So we want to see more restorative justice. Sex offender management that Senator Costa alluded to can nip in the bud some of these behaviors that evidence shows can turn into more and more bad, more and more harmful behavior in the future. Other than that, I'm happy to take questions. I know we're pressed for time.
Ms. Muir, thank you so much for being here. An interesting note for me all the time is the efforts to strengthen some of these laws usually come from folks always in support of criminal justice reform. And so somewhat inconsistent for me, oftentimes, as it relates, one of the issues, as everyone knows, I love felonies. And I struggle with, on page 3, line 19, limiting that to a 2-year felony. I don't think that there's any other provision in statute that has that low of a felony threshold. There's a lot of reasons for that. And I'd like to make that longer, like 0 to 10. So, comments about that for those who favor criminal justice reform, who don't typically support those types of sentences, but I do.
Yeah, and I think you might hear from a lot of survivors. Dang straight, throw those people in prison forever. But what, as I had kind of alluded to, we want to do something that's helpful. I'm okay with a shorter time frame felony, especially if we're going to, hopefully, with new laws like this, catch people right away, not after it's gone on for 3 years and now we have a rapist on our hands. So I leave it to some of the experts that know more about how our felony penalties work and are they really deterrent at all. Our hope is that we need a structure that catches bad behavior earlier. The penalty needs to be able to swoop in and address it. If there's multiple violations of the statute, yeah, they're no good, throw them away. But that's always up to prosecutor discretion and all the mitigating factors as well.
Thank you, Ms. Muir. On that, I'll just throw that out there to Mr. Barron as well, is that I don't think a person can be on probation for longer than the underlying prison sentence. And so we'd be pretty limited in probation. And so if we're really seeking some type of sex offender treatment or other rehabilitative type programs, I think the court might be limited. Mr. Barron, thoughts about that?
Chairman Nethercott, that's generally correct. Usually what happens is there'll be a statutory authority like in the DUI statute, which is a 756 month for misdemeanor, but it allows up to 3 years of probation within that statute. Also, in the deferred statute, it allows for 3 years probation, even though the underlying offense might be a misdemeanor. So if one of the issues there is that, and I can't think of very many statutes that only have a 2-year thing there, and I would recommend at a minimum that you go to 5. But it gives more tools there, but because ultimately the consequences are there no matter what. And so just probably nobody is going to go to the pen for 5 years right out of the gate, but it does give a judge longer time to put somebody on probation and have them monitored in some fashion.
All right, thank you, Mr. Barron. Any questions for Ms. Muir before we move to our next witness? All right, thank you.
Thank you.
Then I think we have Ms. Petrie. Ms. Petrie, welcome to the committee.
Thank you.
Welcome. Please introduce yourself to the committee.
Good afternoon. I'm Jennifer Petrie. I live in Park County here in Wyoming. And before I begin, I'd like to thank all of you for logging on to this Senate Judiciary Committee meeting. Senators and Chairman Nethercott, I am here to support changes to Senate File 87, Voyeurism, with regard to penalties, definitions, and to add a line that I feel is appropriate and needed. Our current voyeurism law is 16 years old. It was written before Facebook, before the first iPhone, and before the first Android. So it is time to update the law to take into account how easily voyeuristic pictures can be taken and disseminated right now, and to clarify exactly what voyeurism is and isn't, and to clarify that in the state of Wyoming, we do not allow people to take pictures or view nude or partially nude people without their consent. I want to tell you all what prompted my decision to be here today. Some of you have already heard what I have to say about that, but I'm going to revisit that briefly. So it was summer and I was feeling good going to the grocery store. I bought a salad, normal day. As I went to the self-checkout, I walked out to my car. As I was opening my car door, I turned sideways like this, opening the car door, and I brushed up against a man. When I turned and looked down, I saw that the man had a phone that he was holding underneath my skirt. He was so close that I could feel him. As I turned to look at him, he ran and he hid. I got in my car, I looked around the parking lot, I was unable to find that person. The Green River Police Department, where I lived at the time, did a great job locating the perpetrator. They scoured hours of footage from the store. They found a video that showed the man waiting in the foyer of the grocery store for me, following me out to my car. The video showed him closing the distance between me and him, and then putting his hand out and putting his phone underneath my skirt. So with the information from the video, the investigator was able to track down the perpetrator on Facebook and track down his location. I was able to identify the grocery store pervert in a black and white lineup. This investigation took hours of time and effort from the Green River Police Department. However, the investigator warned me that voyeurism is rarely charged and used in Wyoming due to the current laws. A deputy in the county attorney's office did review my case, and despite video evidence and due to the vague manner in which the law is written, the prosecutor declined the case. She apologized, saying that she wished she could do more and that she too shops at the local grocery store and does not want to be the next victim. I took a close look at the law and I talked to several attorneys, including former prosecutors. I discovered that the law is written in such a vague manner at this time that the second section is not usable. It prohibits such a wide range of activities that it inadvertently prohibits lawful activities. With the current wording on our books in the state of Wyoming, it is a felony to take a picture of someone's eyes under a cowboy hat. Meanwhile, it is not necessarily against the law to take a picture up someone's skirt if they are wearing panties. This makes the law risky to use by prosecutors. Any conviction using the second part of the law could be overturned on appeal as unconstitutional, as we all saw in Massachusetts, where they had previously a similarly written law. I understand that there has been some discussion about whether or not the county attorney's interpretation of the law was accurate and whether or not the Green River grocery store pervert could have possibly been charged. In my case, the question was not, did the act occur or not, but rather it became, how do we interpret this law? My eye suggests that when a law is so nebulous as to elicit such a debate, it is time to amend. I have discovered that I am not the only person who has been negatively affected by this vaguely written law. In 2010, another woman in Wyoming was unable to have her tattoo artist convicted of voyeurism after he secretly filmed her private parts during a tattoo session and shared her images with others. 2 students at a Wyoming community college were unable to find justice or relief when a perpetrator filmed their private parts on an activity bus after they fell asleep and their shorts fell to the side. I want to be clear that this is not a women's issue. In one local Wyoming recreation center, a young man in his 20s was caught taking pictures of other men naked in a locker room. What he did not specifically fit the definition of our law. In another situation, a woman took pictures of her boyfriend's genitals secretly and upon their breakup distributed those to her friends for ridicule. Because these cases are rarely charged, we cannot know how many times this happens and the perp never sees a consequence for his actions. It is well documented that people who begin with voyeuristic type crimes often escalate into assaults or worse. We need to be able to identify, apprehend, and adequately deter those who choose to offend the state with their obscene behavior. I would like the lawmakers to accept the changes that have been written into the existing amendment draft. These changes take care of the cowboy hat dilemma. I would also like to propose that we add under section B 2A, and I'm not sure if I'm citing that right, another paragraph that says, C, nude or partially nude customers participating in legally appropriate activities such as massage, medical procedures, tattoos, piercings, etc., are also covered. Under the definition of intimate area, I would like to add the words anus and perineum. Here is my ask. Let's rewrite the voyeurism law and be more specific and usable by our law enforcement community. Let's make it clear to all potential perpetrators of this crime. Wyoming values privacy. Upskirt pictures are illegal. Transmitting nude and partially nude pictures taken or distributed without consent is illegal. And there will be consequences for those who do not respect the privacy and dignity of others. I agree with Senator Nethercott on increasing the felony sentence. And I do have a comment about Mr. Kolb and adding the word knowingly. I would like to know if he does want that to be added or if that is still up for debate. How would this be defined? How could we read someone's mind to determine whether or not they did something knowingly? And what other types of statutes require us to say that somebody did something knowingly? And I'd also like to thank Senator Cost for bringing these amendments to this bill forward this year.
Thank you, Ms. Petrie. Any questions for Ms. Petrie? Okay, seeing none, Ms. Petrie, we thank you for sharing your story. We know that takes courage and you participating in the legislative process. With that, we do have a significant amount of other public comment we need to get through. I want to make sure those folks get heard as well. So thanks for being here today. So with that, I think we have Ms. Anderson. Ms. Anderson, welcome to the Senate Judiciary Committee. We really appreciate having you here.
Thank you, Madam Chairwoman, and the Judiciary Committee for allowing me to speak today. My name is Sophie Anderson, and I'm a senior at Cody High School, and I'm speaking on behalf of Cody Youth for Justice in support of Senate File 87, the Voyeurism amendments. Last year, I was on a team of 3 other girls who were very passionate about the Voyeurism bill, and we lobbied at the state legislature, but this was just a small step. It was a good one, but there is a lot more that we can do. The bill as it stands is very vague and makes it very hard to prosecute crimes of voyeurism, as we just heard a personal story. And it's also, which if you're a person who has just experienced such a horrifyingly exposing action, it's exceedingly frustrating to then find yourself struggling to find justice. This amendment would clarify the details as what is intimate areas and allow for different levels of prosecution depending on the degree of the crime. Such like viewing is not the same as photographing, which is not the same as distributing, and they should not be treated as so in the courtroom. As a woman, this is something that I'm very passionate about, and I'm sure as people who probably have daughters or granddaughters or is a woman yourself, I hope that this may accentuate the importance of the bill. Thank you.
Ms. Anderson, thank you so much for being here and participating in this process. It's great to have young people like you here to share your thoughts and understand how this is important for you. So thank you so much. Any questions for Ms. Anderson? Seeing none, we'll go to Mr. Thomas. Do we have Mr. Thomas?
Madam Chairman, I do not see him in the attendee list.
Okay, thank you. I'd also like to hear from a witness who I believe would like to share with us her experience, but is going to not turn her video on. So if we can allow her into the room. And ma'am, thank you so much for being here and welcome to the Senate Judiciary Committee and having the courage to to share with us your story. Whenever you are ready, please feel free to give us your thoughts on this bill.
Thank you, Madam Chairwoman and committee members. Are you able to hear me okay?
We can, yes, thank you.
Okay. Thank you again for allowing me the opportunity to testify today regarding the voyeurism statute. I am a victim of this crime, therefore choosing not to be on video today. And at this time, if it's okay, I'd like to proceed forth with my statement. First off, I'd like to briefly explain the circumstance that has led to me being here today. In June of 2019, at my place of employment at that time, after exercising on my lunch break from work, which I did quite frequently, I returned to the office to change back into my work clothes. Most, if not all, of my coworkers knew that this was a common thing for me to do on my lunch breaks, especially in the summer months. The women's restroom at the office was just a single room. It was not the type of restroom that had various stalls. Upon going into the restroom and taking my clothes off to change, I crouched down to remove something from my gym bag and happened to glance under the sink of the bathroom and noticed a fairly small round webcam looking back at me. Of course, in sheer panic, I clutched the camera, not really knowing what to do. I quickly threw my clothes on and exited the restroom to find my boss. In the meantime, the person responsible for this crime had been hanging out nearby and saw me exit the restroom. He then deliberately looked in the bathroom upon my leaving and realized the camera was gone. My boss was informed of the situation and the police were notified. Said coworker did admit to the police that he had placed the camera in the restroom, but he claimed it was the first and only time and that he had never done it before. The police, through their investigation, ended up searching his workspace later and located a memory card which contained over 100,000 images and video recordings, as well as audio recordings that were all located on the same memory card. The images and video dated back to August of 2018. It was very apparent he had been placing a recording device in that bathroom for quite some time undetected. The device showed him taking test images, ensuring that he was getting just the right angle and placement of the camera. He ended up capturing images and video of 4 different female coworkers, one of them being myself, over the course of that year. I would only imagine more images and videos existed that were never recovered. It's sickening to think of how many victims he potentially had. The 2 counts regarding the audio recordings, which he admitted to police he had also been guilty of, also known according to Wyoming law, and I think their Wyoming statute 7-3-702, if I'm not mistaken, the crime of intercepting communications were dropped in exchange for his guilty plea to the voyeurism. However, it doesn't make him any less guilty of those crimes. What's interesting to me is that the audio recordings that he captured, if he had been convicted, actually carried a harsher punishment than the voyeurism counts did. Illegally recording a person's conversation without their consent carries a punishment of up to 5 years per count. However, the crimes that were committed against me of voyeurism, the harshest punishment given currently is up to 2 years in prison per count, according to the current Wyoming law. How is it possible that illegally capturing a person's conversation without their consent can carry a stricter punishment than if you had video recorded that same person using the restroom without their consent? Therein lies the problem that I'm here today to address. Not only was this a humongous violation of privacy, to say the least, but according to the current voyeurism laws, this crime is also not viewed as a crime of a sexual nature. A person who commits these types of crimes is doing so under no other pretense than a sexual one. In my particular instance, the person guilty of these crimes did not place a random camera in a random bathroom, hoping to capture a random stranger without their clothes on. I was targeted, as were the other victims that he violated in the same manner. He knew that I had to change my clothes in that bathroom. He knew what time I'd be returning to work, and he knew when to place the camera, hoping it would go undetected. He also strategically placed the camera in an opportune spot. I think anyone under the sound of my voice would agree that this was most definitely a crime of a sexual nature. Back when these laws were first put into place, technology did not exist like it does now. This law was probably protecting innocent people from what we'd refer to now as a peeping Tom. However, in this day and age, and with the amount of technology available, the current punishments for voyeurism are not enough. The people committing and being convicted of these crimes should be considered sexual offenders and a threat to not only their victims, but to everyone around them. If a camera can be placed in a doorbell or even a ballpoint pen, a camera can be placed anywhere. When it comes to cameras being placed in restrooms or fitting rooms, this is a serious problem that should carry a harsher punishment. I may not be able to affect the punishment given to the person who forever changed my life by their deceitful and heinous actions, but my goal today and moving forward is to give victims of these crimes more peace of mind than I received. Not only was he given the least amount of punishment, but he was not required to register as a sex offender. And in my opinion, he should be in a database with all of the other sexual predators that live among us. He should be considered a threat to society. With your help, we can provide justice to the victims of these crimes. As it stands now, the people guilty of these crimes are getting away with a mere slap on the wrist for the life-altering crimes they're committing against others. Just imagine if your wife, daughter, sister, or mother had been violated in this way. What type of punishment would seem sufficient to you? I don't plan to stop with, hopefully, the changes that we make here today. I will continue to fight for myself and other victims of these crimes until there is a suitable punishment in place and required time on a sexual offender registry. Please help me to take a positive step in the right direction to make these much needed changes. This is the end of my statement today, and I would be more than happy to answer any questions that you have for me.
Thank you so much for sharing your story, and we are so sorry to hear what happened to you and to be violated in such a way, and having the courage to take action and participate in this process with us and Senator Koss to help make a difference and prevent this type of conduct and again. So thank you so much for taking a stand and sharing your story with us. A lot of courage, and we appreciate hearing from you. Committee questions, comments? Senator Kolb?
Thank you, Madam Chairman. I just want to clarify a little bit. I think it's a terrible thing. That's what happened to that young lady who testified, and the word knowingly has nothing to do with a situation as this. It's a question of clarification, a legal term, and I think this legislation's been long needed with the advent of the technology that we currently have, a portable movie machine in your hand. And I think it's high time we do something about it, and at least maybe have a further conversation about enhanced penalties under some circumstances might be appropriate. Thank you, Madam Chair.
Thank you, Senator Kolb. Sounds like your story and your efforts are making a difference, ma'am, and we appreciate you being here today. With that, I do think there's additional public comment. Looks like Mr. Thomas might have joined us now. Mr. Thomas? And if there's anyone else in the waiting room that would like to testify that hasn't yet, please raise your hand. And there's that icon on the bottom. Welcome, Mr. Thomas. Welcome to the Judiciary.
Thank you. Before speaking, thank you very much. Before I start speaking, I would like to thank Chairwoman Nethercott and the Judiciary community for letting me speak. I think it's awesome. My name is Andrew Thomas. I'm also a senior at Cody High School and am too part of Youth for Justice. The current voyeurism bill that was passed quite a long time ago improved from what it had been in the past, but it was still left extremely vague, and as such, it's been allowing people to still get away with this crime, as you've just heard from those brave ladies who spoke about their experiences. By implementing these amendments, we can outline more more punishments and guidelines for prosecution of voyeurism, because otherwise nothing's ever really going to be done about it. It's too vague. Even though I'm a guy and I've obviously never experienced anything like this, I probably never will because I'm privileged to do so. I can imagine it's exceedingly frustrating for victims of voyeurism to go through the legal system and then have nothing happen, nothing occurs. And so that definitely needs to change. I think it would make a lot of people who have never experienced it feel a lot safer, and it would make those people that have experienced it, I think would give them some closure for what's happened. Thank you for letting me speak, and I'm happy to answer any questions you have for me.
Mr. Thomas, thank you so much, and wonderful to hear that you participate so successfully in your community and in your school with Youth for Justice. I think that's a wonderful program, and I remember seeing you when you came before down to the Capitol. So thanks for participating in the legislative process and hearing your comments and getting a different perspective, very valuable for the committee. So thank you. Any final questions from the committee for Mr. Thomas? All right, with that, we'll move to Mr. Birkeland. Mr. Birkeland, welcome to the committee. If you would start your camera and introduce yourself, we'd be happy to hear from you. We are running short on time, and I'm sorry to be in that situation. We'd love to hear from you for about 5 minutes. Is about the limit before the committee needs to start working the bill.
Let's see if I can get a picture. Oh, sorry for the picture. I'm Bruce Birkeland. I'm with the Wyoming Youth Service Association. The Wyoming Youth Service Association provides programs and prevention and early intervention for youth and their families, to include crisis shelters and group homes and residential treatment. Won't take 5 minutes. I would just say that we're in support of any law that it can help prevent sexual abuse of young people. People we have in our crisis shelters and in our group homes have been victims of that, and not all, but certainly a fair number of them. And anything that can be done to help prevent that would be greatly appreciated. I think this bill could do that in terms of the clarification of voyeurism and what all is included in that, by the increase in supervised probation and encouragement of treatment. I would also add that I think the amendment suggested by Attorney Barron would be helpful in terms of making sure it's coordinated with statutes that affect minor to minor. And for those cases, certainly our programs also end up working with young people who have made those terrible mistakes and have had that problem and are in treatment for addressing those issues. So I think making sure those things fit together would be very helpful. Stand for any questions.
Mr. Birkeland, thank you for being here and your work with the youth of this state, making a difference in their lives. Any questions from the committee? All right, seeing none, really appreciate you being here and having your viewpoint, very helpful. There's additional people in the waiting room, so if you'd like to testify, go ahead and raise your hand. We've still got a little bit of time. All right, seeing none, committee. Public comment is closed. So committee, back to you. What is your pleasure on the bill?
Move the bill.
Moved by Senator Kolb. Is there a second? Seconded by Senator French. Any amendments on the bill? Senator Cost.
Thank you, Madam Chair. I'd like to refer to a couple of amendments that Mr. Barron had talked about, and then refer to some others with some clarification as to why they're there, if you approve of that. But I would do it in two different amendments, or do you want them all? I think broken up would be better.
Let's break them out.
Okay. So Mr. Barron had suggested that on, it's not in here, but Romanet 4 on the bill needs to have the period at the end of fitting rooms changed to a semicolon. And at the same time, not to take any thunder away from the good senator from down south, he also suggested except on line 16 after Romanet C, except as set forth in Wyoming statute 6-4-305. And then it would continue with a person who commits. And that would be my first amendment.
I'm going to break you down into two amendments there. So let's start with the first request from Mr. Barron dealing with that period on page 2, line 18. And was that your understanding of what he identified as needing to be removed?
Madam Chair, that was what he had identified, was so that when we go to our added 5, there wouldn't be a period on 4. It needed to be a semicolon so that it would continue to the next.
So Senator Cost, is your motion that on page 3, line 14, to delete the period and replace it with a semicolon?
Are we looking at two different versions? Because my line 14 says Romanet 5 bedrooms and then semicolon or. I might have a different version.
I was on the wrong page. No, we're on page 2, line
Okay.
18. Page 2, line 18. It's your motion that you would like to remove the period and replace it with a semicolon. Is that correct?
Line 18 would not be correct because that's after Romanet 6. It's Romanet 3 that needs to have it, which is not currently listed because it's in the standing bill. Romanets 1 and 2 aren't listed. Romanet 3 is there and it has a semicolon and the or was canceled. And then Romanet 4 is not listed and it's the one that had the period because that was the end of it previously.
Oh, I see.
And so Romanet 5 and Romanet 6 were added, thus the semicolon to continue to the other 2 Romanets.
Okay. So let's clarify that amendment so that everyone understands. So we are making an amendment to language that doesn't exist in the bill draft. Is that right? And so
it exists in the statute, but not in the bill draft.
Correct. And so in Romanet A4, the period needs to be deleted and replaced with a semicolon. And I'm sure this is a drafting issue, and we'll make sure that happens with LSO.
Okay.
So I think that that's probably just fine, but we'll make sure that that gets corrected, and we all take note of that as this bill moves forward, and we'll get some direction as well from LSO about drafting and how that would be corrected with a conforming amendment. But we'll properly do that motion. And so Senator Cost's motion is to, on page 2, it would be around lines 13, is to ensure that after subsection A4, that the period is deleted and a semicolon is added. Is there a second? By Senator Kolb. All those in favor, please raise your hand. All those opposed? Okay, that motion has passed. All right, Senator Koss, let's go on to the second topic.
Thank you, Madam Chairman. The second excuse me, the second topic is, or amendment is on page 3, line 16. After Romanet C, insert, except as set forth in Wyoming Statute 6-4-305, and then continue on with a person who commits.
Is there a second? By Senator Kolb. How is Judy doing, our session staff? Are you with us?
I am with you. Do we need a comma after that?
Madam Chair, can you hear me?
We can, Senator French.
I cannot hear anyone, so I don't know what's going on after Senator Cost on 13 added the 4 and then fitting room, dropped the period and put a colon or whatever. That's the last I heard. So I don't hear anybody. So my connection's bad or something happened.
Can you hear me now?
Yes, I can.
Okay, looks like maybe it just cut out for a second. We did pass that motion addressing the concern over the period semicolon piece.
Okay.
And now we're on the second requested amendment that Mr. Barron mentioned, which was to do the statute reference to the minor statute. And that's on page 3, line 16. And we have our session staff who's getting that motion down. And Senator Cost did a great job saying that. And we'll have him do it again for your benefit, Senator French. It's been seconded by Senator Kolb. And so, Judy, this is the motion. And so, Senator Cost, if you would please just restate it.
Thank you, Madam Chairman. On line 16, page 3, after Romanet C, insert, except as set forth in Wyoming Statute 6-4-305, and then follows a person who commits. So then it's inserted right in front of a person who commits. Okay?
Judy, did you get that?
Yes, I did.
Great. Discussion on the amendment? All right, seeing none, all those in favor of Senator Cost's amendment, please raise your hand. All those opposed? It's unanimous. All right, any further amendments, committee? Senator Cost.
Thank you, Madam Chairman. A lawyer that I had look at this proposed 2 more amendments, and I don't know whether I should bring them up or not, but I'm going to bring them up just so that there could be a little discussion on them, unless you'd prefer not.
Yes, Senator Cost, I'm going to go, for time purposes, I'm going to trump you right now.
That's fine. You trump me. You have that authority.
I'm going to make a motion that on page 3, line 19.
Change it to 5.
Change it to 5 years, 2 to 5 years. Is there, and that's seconded by Senator Cost. All those in favor, please raise your hand. That motion has passed. All right, Senator Kolb, do you have a very specific motion?
I do. I was we're a short time here. Page 4, line 21, and a discussion about 3 to 5 years, changing that time period. Is that appropriate?
It's up to you, Senator Kolb, if you want to do that. So maybe tell us why you think that's important.
Well, because I don't want it to be less than recording a voice. And I think that's what you had just done with that last amendment. The penalties in recording someone's conversation serendipitously, I think it should be at least equal. Or, I mean, I realize it's short notice and we're out of time, but I wouldn't I wouldn't like it to be a lesser charge for recording a voice. That's all. And I think that's inappropriate if it is less. And maybe I'm in the wrong section here. It's kind of, we're flying through this now, kind of at the end. And I just wanted to propose that. And maybe if if this is improper, have a conversation about that and just discuss it in the group, I suppose, this time. If you think it's inappropriate, then fine.
No, nothing is inappropriate here. I think it's just fine. We actually have 7 minutes. From a lawyer's perspective, I can bill a lot of money in 7 minutes. So we've got plenty of time. So buckle up. We'll get it done. 7 minutes is fine. So the question is, these are regarding terms of probation. I think if we go back and you look up at line 7, we're under subparagraph E, and it states, in addition to the penalties specified in this section, a person guilty of the offense of voyeurism shall serve a term of supervised probation. What's interesting there is we have the word shall. So we're taking full authority out of the court, which may be a problem because there might not be the resources associated with that. We might not want to make that, we might want to think about that shall, but not right now. It's fine where it is. And these are terms of probation for what should be served. So just important to recognize the difference between exposure to prison sentence versus probation. But I think it's a fair policy statement for you to want to increase on page 4, line 21, the 3 to a 5. Is that what you're thinking of doing?
Yes, because I think these type of crimes we're talking about aren't a one-off crime. I mean, it's usually a habitual issue with someone. And because of that, they probably do need more supervised probation because of the inherent issue with this type of offense. And I think it's appropriate they should be supervised longer just because, they're liable to fall off the wagon, as they say, I think. And supervised probation, I realize it has a cost to it, but the cost of these folks reoffending seem to be more than the probationary cost, I think, to the public, in weighing both of the sides of the argument. Like, where's our money more well spent? Trying to protect the public or not? And I think it's a worthy conversation. And I guess I'd propose that amendment if have some discussion.
Senator Cole, was it your original suggestion to do not less than 3 to 5 years? Or just change it 3 to 5?
3 to 5 would be, I know it sounds like a better idea. Maybe it gives the court some discretion, but
I second that, Senator Cole.
Okay.
So I second your motion that on page 4, line 21, Judy, here's another motion that we add the language not less than 3 to 5 years to 3 to 5 years. So we're adding 5 years in addition to that. Does that make sense, Judy? I don't know if we have her. Ms. Creech, did you get that?
I'm sorry, I didn't turn it on.
That's okay.
It's going to say not less than 3, and then the word 2, and then 5.
Correct.
Okay.
All right, all those in favor of that amendment, please raise your hand. All right, that amendment has passed. All right, Senator Kosh, you've got a couple minutes if you want to talk about it, and the committee can think about those proposals when we take the bill out.
I was going to say we can, and to cut on time, I can get that out to you guys so you can look at it, and then we can decide whether we want to do something on the first reading on the floor. Does that sound reasonable to you?
It does, Senator Costa, and I know you spoke with one prosecutor, and I would say that this bill has moved through the Prosecutors Association. The bill Senator Costa worked on throughout the summer, and I provided the bill to them. And of course, when you have 23 elected county attorneys and then all of their staff looking at it, they all kind of have a different opinion. But as we heard today, the general consensus is that they do support it and don't have any concerns with it, creating mischief or not working. And so I think that's the important takeaway as we move it forward. So Senator Cost?
Thank you, Madam Chair. And the two that I was going to bring up are more of a, I would say, personal opinion by a lawyer rather than a necessary change. They're not things that are going to make or break the bill. They're more of a repetition, but I will get them to everybody so they can look at them and see what they think. And if there's a thought that we should go ahead and add them, we certainly can. My whole intent was to discuss it with the group, not that I'm in favor or against them.
Well, wonderful. We'll look forward to hearing that from you. With that, we'll do a roll call vote on the bill.
Senator Cooper,
Aye.
Senator French,
I think he was muted.
Senator French, are you muted?
He is muted.
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
and Chairman Nethercott.
Aye.
So the bill passes with Senate File 87, passes with 5 ayes.
Well, thank you so much. Committee, we worked really, really hard today, fast and furious. I know there's some folks in the waiting room that were maybe looking at Senate File 90. I think that might be Mr. Moline, who's hung out with us. We obviously will get to that bill probably next week or in the following weeks in session. Committee, just as a reminder, it is the #1 committee, and we have the highest workload of any other committee. So we work really tough, and that requires us to be really efficient and really fast. And I just want to applaud you for your work. This is kind of what it looks like. And I know it's a lot. The good news is that in session, our meetings aren't 4 hours, so they're not quite a marathon, but the bad news is that it's even faster. So great work today. I appreciate you hanging in and asking a lot of great questions and getting those amendments out. So I'll look forward to seeing you next week. And Judy, I'll stay on to talk with you and make sure we've got all of our work correctly documented.
Thank you.
Have a great night, committee members.